As stated above, the claims of the petitioner number 1, after being approved by the jurisdictional superintendent, was examined by the state level committee for transport subsidy scheme in the meeting held on 26th, 27th, and 28th of May 2014. Records reveal that the chairman of the meeting was the Commissioner of Industries and Commerce, and the additional director, DIC, was also one of the participants. Thereafter, 4 letters, all dated 10/8/2014, was issued by the additional director of Industries and Commerce to the Commissioner of Taxes for issuance of authentication certificate for separate periods. All the 4 letters were replied to the Office of the Commissioner of Taxes on 14/11/14, authenticating the claim of the petitioner. It was only thereafter that the matter was sent to the Government of India for sanction, which was accordingly done on 22/3/2016 for an amount of rupees 200. When the matter had reached finality, the action of the respondent authorities in purporting to reopen the issue, that too on the basis of a vague report, which also mentioned only about 3 dates, is wholly unreasonable and arbitrary. The official view of the court is fortified by the fact that even the police case, which was registered and had culminated in a final report. In that view of the matter, this court is of the unhesitant opinion that the petitioner has been wrongly denied of the entitlement to transport subsidy, which was already calculated, finalized, and even sanctioned by the Government of India. This leaves the court to the issue of grant of interest on the amount involved. Sri R.K.D. Chaudhary, the learned Deputy SGI, has submitted that since the amount in question was transferred to NETPE in time, no interest may be settled on the central government. He submits that in the year 2016, that funds were transferred and the entitlement of the petitioner was also earmarked. Sri A. Kohli, the learned Standing Council, Industries and Commerce Department, has also placed before this court an order dated of the Honorable Supreme Court, by which an order of status has been passed on an order of similar nature whereby interest was directed to be paid. Considering the efforts and facts and circumstances, including the order passed by the Honorable Supreme Court, this court is not inclined to pass a direction for payment of interest at this stage. However, liberty is granted to the petitioner to make a claim for interest in case the Honorable Supreme Court upheld such direction in the aspect mentioned above. Accordingly, it is directed the amount in question, namely so on account of transport subsidy, be released to the petitioner. The court has been apprised that the money has gone back to the central government due to the non-disbursement within the specified time. Therefore, the concerned department, namely the Industries and Commerce Department, is directed to take necessary steps for fresh disbursement of the amount by the central government to NETPE and order release so that the same can be released to the petitioner expeditiously. Petition according to the
How like it?
May petition lordship, my lord. My lord, I beg to mention item number 9, my lord. The petitioner herein, my lord, does not want to place this matter any further, my lord. He already retired. So. Item number 9, my lord.
Okay. Secondary education. Secondary education, you are the Tarangpi. Sri B.K. Das, council, for the petitioner submit that due to flux of time and change in circumstances, the petitioner does not want to pursue this matter any further. Also heard M.S. Tarangpi, the Learned Standing Council, Secondary Education, as well as Sri J. Sharma, Learned Council for Respondent 5, put for para. Petition accordingly stands dismissed as not present. No interim order?
No, no, my
Lord, I am praying for restricting the petition, my lord.
Yes. What is the stage? What is the stage?
Lord, admission, my lord. It was last listed on 1/11/2022, my lord. So it is the provincialization of certificate.
Next week or whenever? Next Monday.
May I please, Your Lordship? With regard to item number 22, my lord, I have filed an affidavit in opposition today, my lord. That means
May I start the method for listing one motion matter?
Motion when?
And next week, my lord, anything.
Motion, no problem.
may I please, Your Lordship? I beg to mention for listing of repetition for admission This matter relates to appointment of interesting headmaster. The matter may be taken up for admission on 29th or any other day.
Matter is of which year?
My lord,
Matter is of which year?
21.
May
Yes.
please the Lordship. Lordship, I beg to mention item 26 of this.
26.
The Lordship, I have informed and taken function of the state of the council.
Hmm.
Lordship, this matter is led by Mr. D. Das, senior. Certain difficulty on his part today. It is adjourned for the day today. For a week or
On the prayer made on behalf of Sri D. Das, Senior Council, matter is adjourned by a week. By a week.
Lordship, mentioned for listing for motion, Lordship. Will mention to me that.
When?
Lordship, as your Lordship. I did not. Until
I don't know. Have you filed?
there's number filed on 19th.
May please Lordship. I beg to mention item number 14. With the consent of the other side, Lordship, let it be taken after a week, Lordship.
14.
Yes, Lordship.
Matter. On a prayer made on behalf of the petitioner, matter is adjourned by a week.
Lordship, that may be fixed.
Item 14, you are there on the other side. Yes, madam?
May please, Lordship.
Convenient of
List on list on 31st of May.
Lordship, this two matter may be fixed for it. One admission and one for order. 22.
21,
Any next? Can it be on witness?
next one is the 31st.
May please, Lordship. Lordship, I beg to mention WBC 3225/22 for listing 13 May.
What is the stage of the case?
Lordship,
What is the stage of the case?
admission
21,
30 May.
Tuesday.
Then Lordship, 1 May, 1 June.
Not Tuesdays and Thursdays. Have it on 2nd of June.
Lordship, then 8 June.
Don't have it on a Thursday or a Tuesday. Those are hearing days. Have on 5th of June.
Okay.
May it please your Lordship, I beg to mention item number 34, my lord. In this bail hearing, my lord, bail hearing matter, case record has been, copy of the case record has been called for, but it hasn't been received. So, my lord, pick another date,
34.
my lord.
Other side. Have you informed them?
No, my
Have you informed them?
Okay,
It's not a journey matter now.
lord.
We'll pass it over when the matter reaches.
My lord, it can be upgraded, my lord, if possible.
Only in their presence. There's no problem in adjourning, but they have to
Okay.
be
My lord.
informed.
May I please, your Lordship, I beg to mention item number 17.
17.
Because senior, but due to his personal inconvenience, he has a ceremony in his home.
Who's your senior? Other side has been informed.
I have informed them yes.
21. Next week?
Next week, 1st of June,
Next week. On a prayer made on behalf of the petitioner. List after a week. 17. Huh?
much of it.
Yes.
Some motion matters relating to a recruitment process that will amendment to be given on 25th. That has happened after the physical verification.
Which matter?
Yesterday's matter, but it's a little bit different
Have you filed it? What do you want? Motion?
motion. Tomorrow.
Have you filed it or not?
Yesterday we have filed.
What is the urgency?
25th is the appointment.
We'll have it.
They are listed for final argument.
Yes, yes.
Now, if it can be upgraded, because we want to finish it off today.
my lord,
There is
We have
some
filed
change.
our affidavit, they have filed theirs.
If you have seen the causes, there is some change in the pattern. There are certain matters which have to be given priority. That's an administrative order.
Very good.
After those matters, we don't have an issue. We can upgrade, but I think 4 or 5 matters need to be taken as per
Actually, in
set.
view of the liberty granted by my lord to make a mention, my lord, we are mentioned.
I remember.
And that we have also difficulty there because architects
Don't talk about difficulty. Today's date was fixed on consent after taking consent of both the parties. It's a different matter. The pattern has changed. It's
yes,
a
ma'am,
different matter.
not for the continuous hearing is going on in court number 1. Matter architect he is appearing on behalf of NIA. I don't that
What to do? Let us see.
let them
Let
ma'am.
us see. We are not passing any orders.
Yes, ma'am.
May please, Mr. Lordship. I would like to mention for the listing of a matter for order on site. Lordship, the matter relates to provincialized service of the petition,
Petition of which year?
Lordship 2021,
21. Not this Friday. They have it in the next week.
Lordship Monday.
Change the date.
May I please, Lord? Lordship, with the consent of the other side, I beg to mention item number 33 of today's meeting.
33.
Lordship, they have filed a petition in open session. We need 2 weeks time to file or rejoin the petition.
Who has filed the affidavit in opposition?
Owner number 6.
Mr. S.K. Das.
Yes.
Have you taken his consent
I have taken it.
on the prayer of Sri Lensu,
Yes, Lord.
Learned Council for the petitioner? Matters in adjourned by 3 weeks to enable filing of rejoinder affidavit against the counter affidavit of the respondent 6.
Yes, Lord. May I pray for fixing a date, Lord? Any date convenient to
23 matter filed it. First we have 23 weeks we have to.
oblige.
My appreciate, Lordship. With the consent of the other side, Lordship, I beg to mention item number 18, Lordship.
1-8.
1 kindly adjourn for the week, Lord.
Here for the petitioner.
18 and 19, yes, Lord.
Yeah, for the
Lordship,
I'm
petition.
respondent.
petitioner.
Huh?
I'm for the petitioner.
Here for the respondent.
Yes, Lord.
Which respondent?
Respondent number 7, Lord. 7 and
18 and 19.
Yes,
On a prayer made on behalf of the private respondent. Matters can adjourned by a week.
9. And fixed for Monday. Lord. On Monday.
Not saying we are adjourning and fixing dates. That's not 1 week.
Lordship kindly date maybe it is a fixed matter, Lordship.
This matter then don't take a we oppose your adjournment.
My senior is in hospital.
We cannot just adjourn and give another date. One date was given after deliberation. Then you adjourn and again seek for a date. Next time also seeking adjournment. Don't give any date. 1 week. Yes, next.
Oblige.
Lordship, I pray for listing of a repetition regarding dismissal from service. It is a 2014 matter, Lordship.
Yes, yes. Important matter. Whenever. When do you want?
Lordship, next week or
Have it on Thursday.
Lordship.
Thursday we'll have it for final disposal.
Oblige.
For listing of the
You're giving a mention memo. Listing of what? Repetition. When do you want?
24th or 25th.
Day after tomorrow. Motion
25th.
matter or what?
Admission
Admission not possible this week. Have it on 31st.
31st.
31st of May. Next Wednesday. Yes.
May it please, my lord.
Yes.
Matter pertaining to compassionate appointment, my lord. Wherein, my lord, because of the inordinate delay caused by the respondent authorities, my application has been in court. If my lord could kindly come to the last order passed by this honorable court, the 25/11/22 order, at point number 11, my lord, if my lord could kindly come, page 4 of the state of.
Yes.
My lord, this point will categorically show that my husband had died on 26/9/2015. I had made my application on 1/2/2016. Thereafter, the DLC.
Yes,
That-
we've read this.
Fine.
Yes, instruction. For whom? Who's for the government? Is the district level, which has
My lord.
district level has rejected.
My lord, my case is not been. My lord, it was not placed on time. First time, my lord, it was.
Understood. The district level has
My
rejected.
lord.
DLC. Yes, DLC. Government. Madam, are you appearing? Hmm? Who's coming?
After some time, my
Wait for a while.
I leave.
Made a practice of provincial election. Petitioner was appointed in the year 1997 in Gogamuk Junior College, now senior secondary school. as a
97. 97.
97.
Then
A particulars was submitted by the college authority before the district scrutiny committee, district level committee, lordship, district scrutiny committee. But district scrutiny committee dropped her name from the provincialization, for which she has left from provincialization from the order dated 4th February 2021, 34, lordship, please. Annexed C. I have got my
yes, yes. Instructions.
I have taken my concurrence before 1/1/2006.
The candidate names are not being shown on the process of we miss the matter. My lord.
Who's for the secondary education?
The candidate.
ST Edu is shown. Day after tomorrow. Okay. We'll directly register to your name
Okay, my lord.
Next Monday, lordship.
next Monday, not day after tomorrow. Next Monday.
Okay. Okay, that is
Third free MK new Senate counsel for the petitioner. Also heard MS Tarangpi, the learned training council, secondary education department, who however points out that the causes has not properly reflected regarding the secondary education. Para, in the interest of justice, list on 29/5/2023 by reflecting as training council secondary education in the course.
okay. That
my lord, matter related to non-payment of family pension matter
Family pension.
since 2008. Kindly see, my lord, the order to 16/5/2020. Kindly pay.
Yes,
May
Yeah.
please your lordship,
here for whom?
Accountant General. We have already issued the PPO to the petitioner.
Yes, Mr.
Nothing has been paid till now. My lord.
When did you take the instructions last?
1 week ago.
When did you? When was the PPO issued?
Lordship, may kindly give 1 week time to the PPO order.
Have you issued the PPO?
Yes, Lord.
You don't know about the date. We'll have it on Monday. Give the details of the PPO. And Mr. Chauhan, you also take the instructions.
Yes.
Not only about recipe, but ask them to have an inquiry in the office. If it's finalized, then you can withdraw it.
Yes.
Okay. Third, we R.S. Chauhan, the learned counsel for the petitioner. who has filed this petition with the grievance of non-payment, non-release of the family pension. Full stop. Sarah, your name, madam?
J. Das,
I mean, J. Das, you're appearing on behalf of whom?
Accountant General.
You're the standing counsel.
Yes.
I
R.
mean,
Ahmed.
Huh?
R. Ahmed.
I am.
R. Ahmed.
Aramir is the standing counsel.
Yes.
You're appearing on his instructions. I mean, J. Das, standing counsel, appearing on the instruction of Sri R. Ahmed, standing counsel, AG. However, submit that the PPO has already been issued. Full stop. The further praise for a week's time to give the details of such PPO. Full stop. Sarah, let this matter be listed on 29/5/2023. Full stop. No, to enable the learned counsel for the parties to obtain instruction. Registry is also directed to reflect the name of Sri S. Bora, learned standing counsel, SCERT, in the cost. Item 1 to Helena.
Lordship, in this
Elementary education, anybody has come? Elementary?
Yes, sir, I'm here for item 4.
No, elementary, who is there?
Item number 1.
Who will come? Or not elementary, we are working for the government.
Government council. Government council.
Yes.
Item 4.
In this matter, Your Lordship, I have received my instructions, Your Lordship. We'll be filing an affidavit, my lord. 2 weeks may be given to us.
So, Gogoi, what is this matter about?
Petitioner appointed as an assistant in 1989. Thereafter, his salary was stopped in 2007. Thereafter, his service was regularized. After regularized, 2007, his salary was stopped. Lordship, in 2011, he was again appointed as a tutor.
Hmm. What is your grievance? Why have you come to the court?
Lordship, that tutor appointment I am
You want to be in the same, the original post.
earlier.
It could grant some time. Part, Sri A. Pukan, the learned standing counsel. Elementary education?
Elementary.
Elementary Education Department praised for and is granted 2 weeks time to file the counter affidavit.
For admission hearing.
Let the affidavit come. We'll have it.
Okay. Keep your bit.
Yes, madam, what is this?
Lordship, matter pertains to passionate appointment. On last occasion, the government was directed to obtain instructions. May I take your Lordship to the last order of 15/5/2000?
We have seen this.
The case of the petitioner was that initially it was rejected.
Yes, 9/7/2020, 2012. Who's appearing? Was there any resolution of 9/7/2012 of the DLC? That is the date, madam.
This instruction is awaited, Lordship.
My lord, they have filed their affidavit, my lord.
Who has filed?
The government has filed the affidavit.
Affidavit filed.
Yes, my lord, after that only, after the, on last occasion, the honorable court, after verifying the records, my lord, was that the case of the petitioner was to be accommodated in another post as grade 3, he was stated of no qualification. So whether he was accommodated or not was the question.
Affidavit filed when?
My lord, oh, my lord, they have given the oral instructions with
That is,
record
the
to the
no
court.
affidavit has
Yes, my
been
lord.
filed.
And on the basis of that, the last order was passed.
Yes, you get the instructions, file the affidavit. These are matters of completion appointments, should not be kept pending like this.
I will get the instruction, Lordship. Instruction will suffice, Lord.
Sri Barua, the learned state, you are the state council,
Yes, Lordship.
state council, praise for, and is granted
2 weeks.
2 weeks time, to obtain the instructions and oblique or file opinion opposition. SR, right?
SR Borua.
May I please the Lordship? Lordship, in this case, what happened, Lordship, petitioner challenged the order dated 28/9/22 issued by the Inspector of School, Kanipur District to the effect allowing the petitioner to go on retirement with effect from 2018. Lordship, on the ground that her date of birth has been wrongly recorded.
Yes, madam.
Yes, my lord, we have the record. The original record. Already record has been received, Lordship. And we have
Can you proceed on the basis of the records or like to file an
We
affidavit?
would like to file an affidavit, madam, to bring on record, madam.
Lordship, in the meantime, they may be rejected to release the salary. Since 2021, the salary has been stopped, and the honorable court in earlier directed them to release the salary at page 23. Lordship. Because she is still in the service.
You are in service.
Yes, Lordship, they have not retired the petitioner from service. They have only said in the impugn order that she is allowed to go on retirement. She is allowed to go. No any retirement order has been passed.
You file the affidavit.
Yes, madam.
The salary may be directed to release.
Let the affidavit.
Otherwise, also she is in cancer patient, Lordship, not in a good condition.
2 weeks time, madam.
Yes, madam.
There is some urgency. I'm a steering with the learned standing council. The elementary, the secondary education department submits that records have been received, and the department would like to file an affidavit. Full stop. Sarah, on the other hand, MSRDB, the learned council for the petitioner, has expressed urgency as the petitioner has not been paid her salary and she is also ailing from serious, she is also suffering from serious ailment. Put the para in that view of the matter. 2 weeks time is granted to the department to file their affidavit. List on, will you have a date? List on 12th of June. 12 June.
Lordship, salary part.
Let it come. Will-
Okay. God bless.
Penalty shall not be a bar for consideration and payment of the current salaries to the petitioner if it is found that she is discharging her service.
May it is my lord, I request your lordship to look into the order dated 17/5.
Yes, we have seen this.
My lord, here what I find, my lord, my friend instruction is there that they say that the betterment mark sheet I have not uploaded in my online. But my lord, after that online, there was a notification by them that where we will place our physical verification of our document. My lord, if during that time they have not asked for my original certificate, if at all I have given, if at all I have not given, then my lord, at this moment, can they come and say that you have not submitted your betterment? That is why a person getting lesser percentage of marks than me has been allowed to be appointed, whereas I have been thrown out. My lord, all my document shows that I am a better candidate than others.
No, the calculation of marks in the selection is done, it's an objective calculation. It is done on the basis of the marks you have secured in the respective examination.
My lord,
You said that in the betterment you had improved,
improved that marks I was there
had improved, but while submitting your documents,
in the online.
you had given the original certificate, not the mark
Betterment.
it in the betterment.
betterment. My
So
lord,
how do they calculate?
my lord, what now they have come to say that the betterment certificate was not submitted.
Exactly.
But my uh, submission before your lordship is this: during the physical verification after the online, they have asked me to come and produce all my documents before them. During that time, I have placed all my documents before them. If at all I admit to their submission that I have not submitted my betterment certificate. During the physical verification, my name was there. But at page your lordship will find. First of all, I take your lordship to page 26, my online application.
No, page 26.
At page 27, your lordship will find what are the documents I have submitted. Your lordship will look into page 27. HSLC admit card is uploaded.
One. You're at page 27.
27. HSLC admit is uploaded. HS mark sheet is uploaded. HS certificate is uploaded. State mark sheet is uploaded. State certificate, delayed mark sheet, delayed certificate, permanent resident, caste certificate, declaration form, and uploaded. Then next page is, my lord, list for candidates for physical
No, here we are concerned with the higher secondary mark sheet.
betterment.
Now you see this uploading at page 27. So far as it relates to the higher secondary mark, we do not. It's not discernible which mark sheet you have uploaded, whether it's the original or the betterment.
Now they come to say now that I have not submitted. But my submission before your lordship is that page 28, list of candidates for physical document verification against their district. Your lordship has got it at page 28.
Right.
At page 29, serial number 17, my name is there. Babita Adhikari.
Right.
Page 17. Next page, my page 30. On 18/3/23, Dhubri was there. I submitted all my documents over there. Then the first list was published, where at page
You're from Dhubri district.
Dhubri, my lord. At page 33, serial number 24, 25, 26 are the person who got below percentage than me.
And that is okay. That is not the dispute.
Next page, my lord, page 34, they have said any grievance, genuine grievance along with documentary evidence regarding provisional merit list will be addressed on 4th and 5th May. So they have placed it, and I have placed my submissions, and I have said everything over there. In page 35, they have not disposed of, and they are going to release the result sheet tomorrow. The next list, my lord, they have published at page 39. Your lordship will find all the percentage below percentage marks are there. Had they have asked for my grievances to be placed before them, they should have disposed of my grievances. If at all not admitting, but assuming that I have not submitted my
Okay,
betterment.
Mr. Vachadu, where have you stated that on the physical verification date you had given the betterment certificate?
My lord, I have stated that I have only submitted all the documents. My lord, at page para 6, my lord, your lordship will find. Where I have stated that wherein she produced all the required documents as mentioned in the state notification. Para
Where?
6. Last
No,
month.
that is not the issue. The issue is a particular certificate of the higher secondary examination. You have two certificates.
My lord,
One is
only betterment was for 2 subjects. And others,
doesn't matter. You have two certificates. One is the original certificate. One is the certificate after the betterment examination.
my lord,
You claim that in the betterment examination you have secured more marks,
more.
and therefore you have claimed but you have not given that certificate.
But what they are saying now, they will be saying now, as my friend instruction comes, that I have not submitted. But my submission before your lordship is this: when they have asked for with all documents and my grievances, was it not their duty to? If
No,
they
no,
have-
you are on a secondary issue. We are not on presumption.
my submission, I have submitted all my
No,
documents.
we'll not fall back on a presumption that you
I have submitted all my documents. What they will say later, they got to produce that I have not submitted. I have submitted. My submission is that I have submitted all my documents.
What do you say?
Let us produce the record, my lord. As per
But
my,
tomorrow the results are coming. How do you
my
protect
lord,
the interest?
I have given a my lord communication. My lord.
Yes.
As per this, my lord, petitioner has submitted this mark sheet. That is annexed A, and my lord, death certificate. My lord,
This is higher secondary.
my lord,
This is the original one, not
my
the
lord,
not the betterment
my
one.
lord. Only this document is submitted by the petitioner.
My lord,
As per
my
the
submission is the record to produce.
No, why should they take a view against you? They have got nothing personal against you.
My lord, every day they are changing their stance. My lord, what has come, my lord, because
No, this is not a case where there is change in policy. It's a simple factual dispute wherein you claim your marks to be counted from a betterment certificate, which you have not submitted.
their submission, but my only submission, my lord, they should have.
Where is your betterment certificate? Mark-
That is at page 19.
19.
One. 22-2, left hand side bottom. It was given to me, and I have submitted my online on 25-2. My lord, even I have submitted my state certificate. I have
Those are not relevant.
online. I have submitted on 25-2.
We don't find any.
Increasing 6%.
No,
My lord,
there is no. There is
English previously it was, my lord, 38. Now
Yes.
it has gone to 68. English previously 38, it has gone to 68, and economics has come down. It was 49, it has come to 40. So increase by around 24 in total. Previously I got 60%. Now, my lord, it is 66%.
why your school has changed?
My lord,
Why the institution has changed?
Virat Nagar Secondary, and it was college because I have changed my place.
Hmm?
Maybe previously it was Hathi Dhura College, and now this is, my lord, Virat Nagar Secondary, Senior Secondary School.
Where is your government of annexure A1? A1?
A1. My lord, there are two.
There is an government paragraph. Mr. Bora, if the certificate is actually there,
My lord,
even assuming that it was not given at that time,
my lord,
but as a matter of fact, there is a certificate
my lord,
from which there appears to have been an improvement in the
my lord.
higher secondary. In this case, how do you protect the interest?
Only-
Tomorrow you're publishing the result.
Only thing is that initially petitioner has not submitted the required document, and verification of document is not for the correction of error of
No,
correction.
that part. And what about the grievance redressal? It appears that within the time specified,
My lord.
prescribed, a representation was filed.
At 2, I will take instruction regarding her representation.
And also you take the instruction how to protect the interest. Today it may not be prudent to dispose of the matter, but
Well.
we can protect the interest by asking you to keep one post vacant.
At 2, I will
That's true.
take.
You also take instructions on
My
that
lord,
part.
my lord,
If something else happens, then we dismiss it.
my lord,
But if actually there is a certificate
my lord,
which is authentic,
my lord.
there are other factors. Maybe the college is different. You have to. It's up
Well.
to you. Because Mr. Rajchandra also may not know what is it exactly. What has been presented to him is presented to us.
My lord,
But if what is his projected is correct, then we don't want injustice.
my lord. At 2, my
At 2 o'clock.
my lord.
you can take this file.
Lordship, in this case, yes, his grievance is that his case was never placed before the DLC. So, Lordship, instruction we have received, Lordship. His
No,
case
no,
was-
that's not, that is not his case. His case, he is aggrieved by the fact that the rejection has been done on a consideration which is not at all there. You said that there was, the application was kept pending at your level and it was rejected because on the ground that it has spent its food. We
Yes,
do not
yes.
find any delay in applying for the food.
Yes, yes. It was,
That rejection appears to have been done mechanically without
that is
looking
correct,
into the factor when was the application submitted.
Lordship.
Maybe they saw that so much time has gone, so their request.
Prior to this also, his case was placed, but not decision was taken in this regard, Lordship. And Lordship,
The one-time consideration is a must,
Lordship,
and one kind of consideration on merits.
Lordship. And Lordship, remand back to the.
We
DLC
remand
for
it
a
back.
fresh-
We remand
fresh-
this back.
fresh,
Your name?
My lord, PR sir.
Yes, sir. Heart City Sharma, current counsel for the petition. Also heard three. I have your three. S.R. Barua, the Learned State Council. For the phone number,
Phone number, Lordship, 3.
phone
Deputy
number
Commissioner.
4. 4.
4
Oh.
is appearing as standing counsel.
No, 4 is deputy commissioner. There is a in marking there is a problem.
Lordship.
It's been correct. For the deputy commissioner, it's phone number 4. The one also state level selection committee,
Yes, yes.
1 and 4. The Pibora, Senate Council Elementary Education Department, accept is also present. Considering the nature of the grievance and as agreed to by the partner, this writ petition is taken up for disposal at the motion stage itself. Suffice it to, it is however to be noted that this case is at the stage of motion since November 2022. The matter pertains to a consideration for appointment on compassionate ground. The petitioner has projected that her husband, Parmeshwar Bora, who was working under the district elementary education, working in the office of the district elementary education officer, Lakhimpur, as an assistant teacher, had died in harness on 26/9/2015. It is averred that at the time of his death, he was working as the headmaster in charge in the number 2 Hemagar. What school or what? What's the name of the school?
My lord, number 2, Dhemgor, my lord.
Hemkor what?
My lord, number 2, Dhemgor, LP.
Try the school. Try Hemkor. Hemkor LP school. LP school. Para. The petitioner accordingly has submitted an application on 1/2/2016 for consideration of her case for appointment on compassionate grounds, which was accordingly forwarded by the block elementary education officer to the Deputy Inspector of Schools, Lakhimpur, by communication dated 24/2/2016. The petitioner could learn that her case was placed before the DLC, which however did not consider her case. Full stop. Para. The current concept Sharma as where is that part?
My lord, paragraph 11 of the pointer 11 of the last order passed by this honorable court, my lord, 25/11/22.
Now where from where do you get? From where is the instruction? That is the court's order.
My lord, the court.
From where was it recorded?
My lord, this was the instruction which was given in the last day by the.
Yes, instruction. Please.
It is the instruction, my lord, 15/11/22 instruction, my lord.
The current concept Sharma submits that it would appear from the earlier of the court which had recorded the which had taken note of the instructions placed on record, placed before the court, as per which, comma, the rejection was on the ground that the application had been put as per government letter dated 2012-2020. Please, the learned counsel submits that the said rejection has apparently been done without any application of mine, as there was no delay on the part of the petitioner to apply for such consideration, and the application was lying without proper consideration before the authority. Riyasar Borwa, the learned state council submits fairly submits that as per the settled law, comma, one-time consideration is mandated, which does not appear to have been done in this case, as the rejection is on a technical ground, which perhaps cannot be, which perhaps has been done without any fault of the petitioner. The standing council of the department has endorsed the intent of the learned state council in view of the aforesaid facts and circumstances. The present petition is disposed of by remanding the matter of consideration of the case of the petitioner for appointment on compassionate ground to the district level committee, comma, Lakhimpur. It is, however, made clear that the delay should not be a ground which should come into the way of consideration, and the consideration has to be done on the merit of the application.
The proposal will stand by the district elementary education officer.
That was already done before a DL. Why a proposal is required? Well, yes.
Highly
The consideration will be done in the next meeting of the district level.
Next available.
Matter pertains to the selection and appointment to the post of principal.
Post of principal.
I have challenged the selection and appointment of respondent number 6. Lordship may kindly peruse the order dated 9/1/2019 passed by your Lordship.
I pay for that timely, madam.
Hmm?
What how we select. Or you can start my lord.
Lordship may kindly peruse order dated 9/1/2019.
9-1.
Fine.
Yes.
Lordship has perused the record. After hearing this matter at some length and after perusal of the records of the selection produced by P.A. Dekha, Land Standing Council of the Secondary Education Department, this court directs the Land Standing Council to obtain instructions as to the marks under the column integrity and STR have been allotted to the respective candidates. This direction is issued after considering the fact that from the perusal of the records and the STRs in particular, it is found that both the petitioner and the respondent number 6 were given the remark very good for the relevant periods in question and appears to be at par. Further, there is no any adverse remark with regard to sub-para 1 and 2 under the said column of integrity, namely earlier penalty and pending departmental proceedings. Release this case again on 23/1/2019 to enable Sri Dhaka Land Standing Council to obtain lawsuit integrity lawsuit. There is no any adverse remark, but I was deliberately given 1 mark less. Now, if 1 mark is added lawsuit, I score equal mark. And the other lawsuit in the category of lawsuit leadership skill. Okay, I have given a calculation in my
We have to hear it from the beginning. You are questioning the BA degree of the respondent 5 also.
and subsequently recently also I have filed another restriction in which case also our classmate, the director has already passed a strict order in respect of our classmate that her BA degree is not met. And on that basis also I have also filed a writ petition and that order
Just tell us if you
I would like to cite the grounds on which I have challenged the selection and appointment of the respondent.
What is this new method?
New method also I specifically challenge the B.Ed degree obtained by the respondent number 6 from Deomonai B.Ed College, because from Deomonai B.Ed College to Zorat School the distance was 350 kilometers.
And this
he
is
did not obtain any permission from the
this is the same respondent here.
same respondent also.
What is the name of the respondent? Beneficiary?
Beneficiary is called Chamolina Bora. And that particular B.Ed college was a lot of basic college also. He was
No, but that issue is pending before the court.
Court.
There is no
this order has been passed.
court order. This is only notice.
Notice.
Notice has been issued.
But
There is no
observations are already there.
But no conclusive findings are there.
Yes, sir. Only notice has been.
Tell us if you want to proceed.
Yes, sir. My first round of challenge is of the
No, we have to know the facts. We don't know the facts. When can Mr. Portable come? Should we start or should we wait for him? Wait for a while. We'll start in his presence. But 2017 matter. We'll try to have it today itself. And top of the list.
May it please your lordship. So, in one view of the matter might have become infected. In the other view, there might be some light. I'll place it as simple as possible. We are serving in a college below, non-government college, when we terminated.
What do you say?
Well, actually, in fact, this case is become infectious because the basic claim for
He
challenging
has kindly said to.
In two
Yes.
views would be there. May I just place it
Let
as
us just have it in a minimum possible time. The outline of the case, then we can take it.
absolutely in a brief, sketchy outline. I'll put it.
Yes,
To be fair enough, otherwise it will come on me. We were terminated from service.
how many of you are there? 3, 4.
We were terminated from service. Eventually, after series of litigation, our termination orders were set aside.
Yes.
So that takes care of one part. So far as non-provincialization of our services, that also eventually following litigations, there's an order of the court, common order, saying that approach the tribunal to do the needful, and those who were given this benefit in your presence, I mean, in your place, tribunal would take care of the whatever order to follow. So this way, the question of provincialization and termination is taken care of. This writ petition was filed as a limb to my challenge to my orders of termination, saying that the principal who had issued the orders of termination was not eligible to do so because although my termination was of 2009, in 13, the director of higher education says he's underqualified. Now, since I've got two
Who is
reasons,
underqualified?
the principal,
As to hold the post of the principal.
he's underqualified for
That
just
is, you are questioning the jurisdiction of the principal.
initially, yes. And we have made a statement in paragraph 8 that this is a limb to the challenge, which otherwise will go unchecked. Now our termination orders are taken care of. Provincialization part, the tribunal taken care of. This part, whether the the UGC goes for inquiry or not, up to them. Otherwise, basic contentions are made. But this unilaterally also raised the contention that the degree was obtained by fraud. That part, regardless of our release we got, may be alive for the future course of action to come. He may spring back. Otherwise, it's gone.
Heard as Bonnie Planet counsel for the petitioner. Also heard.
member respond.
Yeah, the prayer is for that legitimate PhD degree not getting it. Against that, but he has not been made a respondent. It's not maintainable.
No, we are not. We
The
are.
person against whom the allegation has been made, he has not been made even the part in the allegation. The party,
Principal is not a party.
not a party.
My name is not.
Not a party.
Okay, doesn't matter. The order which you are proposed to be, we are proposing, I will not make any.
No.
What, then,
I'm
Three-
petition number
Davinder Training Council, secondary education, higher education. Usually you are for the UGC, HMO, UGC, and R Islam for who's the
petition number 6, I think.
principal. You are not made party by name.
Number by name.
Because
But
my,
allegation is against me
Uh,
personally, but not
Personally,
made
the-
party. Even the challenging the
You are
appointment
not
order
made party by name,
because the thing
only by the post.
only by.
Sri Bonik has fairly considered that there were a series of litigations connected to this issue, which on two broad grounds, namely termination from service and provincialization. Both the issues
That's the comment.
have been conclusively determined by this court, whereby the terminations have been set aside, and so far as provincialization of the services are concerned, the petitioners have been directed to approach the jurisdictional tribunal, educational tribunal. In this case, Sri Bonik submits that substantially the grievances of the petitioners have been redressed. However, in this case, another point in support of challenge to the termination order was taken, which pertains to the jurisdiction of the principal who had issued the termination order. It is submitted that the principal was not even qualified under the law to hold the said post, and therefore could not have exercised the powers to terminate. That, on the other hand, Sri Ravinder, the Training Council, Higher Education Department submits that though, on principle here, the petitioner may have a point, the incumbent who was holding the post of principal at that time has not been made a party respondent.
By name.
By incumbent who has said. He therefore submits that no effective orders can be passed in this petition. The state view of the Learning Council is also endorsed by Sri A. Shamwa, the Learning Council, as well as by our Islam. The Learning Council for Responsibility, who additionally submits that there is no life for the vector at all,
Subsequent developments also there concerning the principal.
at all to be adjudicated as the issue has been conclusively decided, and no further appeal has been filed. That in considering the effort that submitted, this court is also of the view that there is no life for the vector to be adjudicated. As regards the point questioning the eligibility of the response number 6, this court is of the opinion that since the response number 6 was not made party by name, the state issue cannot be gone in this writ petition. Therefore, while dismissing the writ, while closing the writ petition due to want of any life for the action, the liberty is given to the petitioner to raise that point
If
in an appropriate manner, if that way.
obliged.
This earlier order
This is a review application. Here, because the case is as such, my lord, advertisement contains that there should be a reservation to be followed for selection of assistant teacher in the area of Karvian. Then, my lord, prior to the judgment passed, which is under review, there was another litigation on the same selection, where also the Lord Single Judge held reservation has to be followed and a fresh select list has to be prepared. Then, when a fresh select list was prepared, my lord, the contention was that reservation was not at all taken into consideration, and it was admitted by the respondent Karbi Anglong in their affidavit.
That was your stand.
My
That in spite of the policy of having a reservation, it was not followed.
and followed, and the affidavit they have consented to it. My lord, in the writ petition, the paragraph says as such that, my lord, I'll just read that last. And the law relating to the reservation was not applied. That was the stance taken by the Karbi Anglong authority. And, my lord, that aspect of the matter was never considered by the learned single chief, not a single whisper as regards the reservation. So I approached the division bench. Division bench gave me a liberty to file a review that I have annexed at page 88. That is why I am before you. Page 88, your lordship will find.
First, let us
Advertisement.
have a look at the
Advertisement.
first order of the court.
My lord, there are a bunch of writ petitions. The place where my case was considered at page 72, your lordship will find.
72.
Para 19 on. Previously, the facts were given where, my lord, regarding reservation, nothing was
Paragraph 19.
Para 19. From the narration of facts notice above, it is seen that petitioner when initially appointed as a drug teacher.
One second. Para 72.
Para 9.
There are 272.
72, then 70. Para 19 of the judgment.
73.
From the narration of facts as noticed above, it is seen that the petitioners were initially appointed as ad hoc teachers.
There were a number of petitions.
Number of petitioners were there.
You are one of them.
One of
Single petition.
single.
Okay.
My lord, the persons who I was appearing was for WPC number 5838 2009, and, my lord,
Private 2009.
2009 and 5660 2000.
2010. 9.
Advertisement of 2002. My lord, if your lordship just allows me, I take your lordship to the advertisement at page
No, it doesn't matter. You read this 19.
para 19, my lord. From the there is nothing on record to show that the appointment was preceded by any selection. When regular selection was held, petitioner has participated in the selection, but unfortunately they could not be successful. The provisional checklist which was published on such and such, which led to publication of the final list on such and such, was put to challenge as noticed above on various grounds. All these grounds were found to be untenable by the writ court, paving the way for publication of the final list on such and such. More than a decade has gone by since the initiation of the selection process. There has been litigation after litigation on various stages of the selection process. Such litigation cannot be an endless exercise. After all, this court in its common judgment and order had given it imprimatur to the selection process. Therefore, it is not open to the ad hoc teachers to once again launch another challenge to the validity of the said selection. Moreover, such and such the selected candidates have not been arrayed as respondents. In the absence of selected candidates, there cannot be any adjudicated on the validity of the selection and appointment. That apart petitioner have participated in the selection now cannot question the validity of the selection process on the ground that the interest of merit was not properly assessed. Even selection process do not confer any indivisible right to appointment. For the above reason, the court made into its petition according to. But, my lord, your lordship, it's true that Madan Lal has, since Madan Lal, then Rashtrapati came over in 1997, which says that it was distinguished. It is absolutely something which was not there, has not been taken consideration of. And when it was an admitted fact in the affidavit in the writ petition of 5660 of 2009, the reservation was not followed. And in the earlier judgment of this Supreme Court, your lordship may turn to page 45, para 18.
We'll come to 40. Where is the
Advertisement.
where is the division bench? Is it at page 88?
My lord, division based judgment.
Is it at 88?
88.
We'll just come back to it. Mr. What do you say?
Lordship will first look into my review petitioner, my lord. That who is the petitioner, my lord? Long my lord, first page, an application for review of the judgment passed in WPC 566/2009.
Where are you reading?
The first page, my lord, of the petition review petition.
Just an application
For
for
review of the judgment dated of a particular repetition, my lord, 5660/2009.
Yes.
And petitioner number 1 is not a, my lord, party of that part, not a petitioner of that particular petition.
But my lord, what happened?
No,
2007,
we'll come back.
all the judgments were clubbed together, and my lord, a single common judgment was. He was a party to another writ petition.
He was party of another repetition, not this particular review petition, my lord. Review was sought for only this particular repetition. 5660/2009. So the petition is confined only 5660/2009.
And the second writ petition,
Second petition is Topon Kemprai. He is one of the petitioner of 5660/2009.
is one of the petitioners.
My lord. The lordship will look into the repetition, my lord. Repetition filed by 5660/2009, my lord. Repetition.
Yes.
In the repetition, there is a no whisper that the Topon Kemprai is a person belongs to the Cyril tribe, plains or hills. No statement has been made in the repetition. No documents that he belongs to that particular community. Without making a statement in the repetition that the person is belongs to a particular community, and whether he claims the, my lord, only a statement is made in the repetition, only paragraph 28. There is no statement.
In this 5660, there was only one petition.
My lord, there are several petitioners, my lord. There are 7 petitioners.
But one of them has
Only one of them filed a, my lord,
review.
petition.
Okay. And
The-
for him,
My lord,
there was
he has
no statement that
no
he belongs to him.
statement in the repetition that he belongs to a Cyril tribe. Without making a statement in the repetition whether he claims the reservation under the Assam Cyril Tribes of Reservation Act or not. Lordship will look into the paragraph 28. I'm reading it in the
Page-
repetition.
page-
Page 18 of the repetition. That only one statement is the made in the repetition.
Page 18.
Page 18 of the repetition.
One second. It has been annexed over.
No, not annexed one.
Page 18.
Page 18, paragraph 28. Only that statement is there.
Yes, what has been stated?
That the petitioner makes to state that impugned marriage list dated 21/11/2009 and subsequent appointment dated 7/11/2009 were not in confrontation with the not
Confirmation.
conformation with the Assam Higher Secondary Education Service Rule 1982 and 2003, provisions of the Assam Women Reservation Vacancy Service Rule 2005, and provisions from Equal Opportunity Protection Right and Full to ensure.
There are 27 now. There are 27.
But are you have taken the
But I'm coming, my lord. My lord, then lordship will look into the my lord review petition. That it is only for my lord, or not review petition itself, my lord. He is concerned with the assistant teacher of my lord art, which is at page 162, my lord.
yes 162 order?
My lord, that is the appointment order, my lord.
Mm.
Total 17 posts were, my lord, fill up, my lord, advertise and fill up, my lord.
Mm.
And the name of the petitioner is not there. And that in the selection list, my lord, his position is, my lord, relevant. His position is not within the, my lord, 17, my lord. His position of the select list, my lord, that has been annexed, my lord. That is in page 105. And his name appears at serial number, my lord, 35, page 106.
10
105 is the select list, my lord. Petitioner name appeared at serial number 35.
105.
105 is the select list. Repetition.
Five, yes.
My lord. And 106, his number is Topon Kamprai. Serial number 35.
Zero, six, 106. Serial 35.
35. So he is not in the zone of, my lord.
How many posts were there?
17, my lord.
How many? 17 posts.
17 posts. And his name is at serial number 35. And above him, my lord, there are some other persons, my lord, who he belongs to, my lord, scheduled tribes. There are some other persons, my lord, who has not been appointed also. They belongs to scheduled tribes. If your lordship look into, my lord, serial
The
number
number of vacancies were 17.
17. And his position is 35. And by any way, my lord, if it is reservation is also there, he is not entitled to, he is not within the, my lord, merit list for appointment, my lord. Within the zone of appointment, my lord. And ST Hills, my lord, only 5% post is reserved, my lord. That means, my lord, only one post. And there are other persons, my lord, who has been appointed. Scheduled tribes plains has already been appointed, my lord. So there is no violation of the act, my lord. Reservation also.
If you're not married, you are
If you are married also, my lord, then he is also now he cannot be appointed, my lord. And above them, my lord, there are some other persons, they have not been made a party in the response as a implicit as a respondent, my lord. Those who are came above in the merit list, my lord. That is the case, my lord, and that is his main campus of the merit list of 2002, my lord. And it was judgment was passed in 2009. They have the selection. Then thereafter, my lord, merit list has been, my lord, approved by this placed before the committee. Then thereafter it was appointed. And now they have sought the review, my lord, on the ground that we have not implemented the reservation policy, my lord. That it appears from that the persons, only one post is reserved for the scheduled tribe. Petitioner has not stated that he belongs to scheduled tribes plains like that way. And the other persons above him were also not included as a respondent, my lord.
But otherwise, on the issue, on the ground of challenge,
My lord.
did you put into application the reservation policy?
My lord, reservation that in the advertisement it is stated that reservation of the government rule will follow. That reservation rule will be followed. That is a 5% post, my lord. Regarding the applicability of the act in the scheduled tribes area, my lord, that is if there is a, my lord, administration of tribal areas, my lord. In the tribal areas, my lord, the dominant persons are the tribals, my lord. Only the reservation of one post, my lord, only the percent of 5%, it will not, my lord, against the, my lord, interest of the, my lord, autonomous council, my lord. So, my lord, we are stating in the affidavit that we have not, in accordance with the Reservation Act, only the 5% posts are there, my lord. So, we have enacted like that way, mentioned in the affidavit. But in the advertising itself, it stated that reservation rule will follow, government reservation rule. That means that we are following the rules, my lord. But the applicability of the act, my lord, only that person we have clarified by way of affidavit, my lord.
My lord, I read the affidavit, my lord. The deponent says that the person whose name figured in the order of merit in the select list are the same person whose name figured in the merit list in order of merit. And the law relating to reservation was not applied.
Where are you reading?
The affidavit filed in the writ petition.
In the writ petition.
There are 9
Affidavit by
filed by my lord writ petition. It's the Joint Secretary Education Karbi Angla order number.
Joyশ্রী Dalagapu.
Joyshri Dalaga. Paragraph 9 we have said.
They said, my lord, the resolution was adopted in 1992. But as per the sixth schedule, my lord, until unless there is an assent from the government, governor, that cannot be acted upon.
One second. Let us come to the affidavit. 10/2/2010 by Joyশ্rী.
My lord.
There are 9.
There are 9. There are 9. Please read.
That with reference to the statement made in paragraph 2 and 2 and paragraph 2 and 2 of the affidavit filed by the petitioner, the deponent begs to state that executive committee meeting of the Karbi Anglong Autonomous Council was held on 17/11/2009, wherein it was decided by resolution number 1 to move the government urgently to exclude Karbi Anglong from the purview of Assam Scheduled Caste and Scheduled Tribes reservation of vacancies and service and post act 1978 and the rules and the guidelines in the said act. Thus, a resolution was adopted in view of the fact that the executive committee of the council had taken a resolution in its sitting on 5/11/1992 that even though the district council had resolved to continue to follow the existing service rules of the state government with regard to recruitment, disciplinary proceeding, adoption of pay scale, etc., the provision of the reservation policy adopted by the central state government shall not be applicable to the district council in later and speed. The said resolution of 1992 was adopted as it was felt that the local indigenous, tribal, educated, unemployed youth deserve special consideration to justify constitutional safeguard as provided in the Constitution of India. Karbi Anglong being a sixth scheduled area, the said act has never been strictly followed by the council while preparing the select list giving appointment. The deponents state that the person whose name figured in order of merit in the select list are the same persons whose name figured in the merit list in order of merit, and the law relating to reservation was not applied. The answering respondent begs to reserve their right to make appropriate submission in connection with the appropriate at the time of hearing if need be.
The resolution was adopted placed to the government, but it was not given assent by the governor. So they have decided not to apply the reservation. And the reservation was not.
Now, what about the your individual the objections raised? First, we can ignore the first submission that 1 is not there. So far as 2 is there, it is maintained. 2, you have not made a statement that you belong
Because,
to
my
the
lord, there was an omnibus statement in para 27, and that in reply to that they have said, I have said that reservation was not followed.
No, that you belong to the reserve
Because
category.
it is, that means that I was admitted fact is that I am a person for the reserve category.
That's an inference. Okay. And
Inference, because I made a
secondly,
statement.
he has pointed out that there were 17 numbers of posts.
Ma.
You were in 35.
Ma.
Then above you there were persons in the reserve category.
My lord,
Now what relief will you get?
my lord, if the
See, review is an
it may
exercise.
go for a fresh selection.
No, review is an extraordinary exercise.
My lord, but this selection
You have
is
to get
in.
some substantial relief only for an academic purpose.
Because, my lord, to certain extent, what I can say, this selection is bad. What is this, my lord? By an illegality, that means, my lord, the selection has been held. And it has, because earlier report also has said, my lord, page 45, your lordship will find.
Now, selection of 2009
9.
at this stage,
Because, my lord,
and after passing, it has gone through a number of litigation. We thought that we could have given you some relief, but now
some
you
consideration, because
no,
this
you'll not
person-
get anything.
these persons, they were in ad hoc previously. They were given a certain kind of direction to consider their case.
No, can you ask the council, AAC, to give preference to you by ignoring the claims of persons who are above you
No.
between 17 to 34?
No. But-
You are at 35.
No.
17 have been given appointment. From 18 to 34, there are persons in your category who are above you.
This aspect of the
And
matter,
number two,
this is aspect of the matter is unknown to us, Maharaj. We could have controverted this. No affidavit to that extent.
and number two, there is no vacancy.
Maharaj.
Can we cancel the
At least,
appointment
Maharaj,
of
let-
somebody?
Let them, Maharaj, give a affidavit to that extent that that person, I am below the merit list. And they, Maharaj, because they have not stated anything in that
No,
affidavit.
we've seen the select list. Select list is there for us.
Because, Maharaj, the whole.
Your
select-
position is 35. That is not denied.
Maharaj,
It is in the read petition, my lord. Petitioner annexed the select merit list, my lord. Petitioner annexed the end of merit.
Okay, we'll pass. We'll consider. We'll pass. Heard. Three. PKR Chaudhary. Then concept for the applicant who, by means of this application, has paid for review of the judgment and order dated 18/8/2016 passed in WP 566029 2009. Also heard. Also heard. MS3 J. Chutia, pending concept EAC. With Hazarika for how are you connected? Selected. P. Hazarika for phone numbers.
24, 20, 31, 40,
Font of give the name. Yes. Your what is your name? Emma Grohl for conversation. We'll pass orders today.
your lordship will first the open court or after?
With personal chapter. There are many matters. Collected here only. Two applicants have referred this review against the aforesaid judgment as mentioned. The principal ground of review is that a particular point urged in the writ petition was not considered at all, while the judgment dated 18/8/2016 was delivered. It is contended that there were a bunch of writ petitions which were disposed of by the common judgment and order dated 18/8/2016. Para 3. PKR Chaudhary, the learned counsel for the applicant, has submitted that a categorical point taken in the writ petition was that in the impugned selection for the post of assistant teacher in the Karbi Anglong Autonomous Council, reservation was not followed, which was in violation of the statute. It has further been contended that in the affidavit in opposition filed by the Karbi Anglong Autonomous Council, the state point was in the state point, instead of being disputed, was to the contrary admitted, and therefore a footnote. He therefore contends that the entire selection was vitiated due to non-following of the reservation policy, which is mandatory in nature. Full stop. He submits that the learned single judge, while passing the aforesaid judgment, did not even consider the aforesaid aspect, which was in fact an admitted fact. Full stop. The learned counsel has also drawn the attention of this court to an order dated 10/2/2017 passed by the Honorable Division Bench in writ appeal 38/2017, whereby a liberty was given to the applicant to the appellant in that case to prefer a review. Full stop. Para. Sri Raj Chaudhary, the learned counsel for the applicant, submits that when a point of law was urged and was not considered, in spite of the point being considered by the contesting respondent, the judgment in question is liable to be reviewed in the interest of justice. Full stop. Para. Refuting the aforesaid submission, Sri J. Chutia, the learned standing counsel, KAAC, has submitted that the present application for review is not maintainable. Full stop. is not mandated for more than one reason. By drawing the attention of this court to the review petition itself, he submits that though the judgment dated 18/8/2016 was a common judgment, the review was sought for only in respect of WPC 5660/2009, in which the applicant number 1 dash Longsing Terang was not even a party, was not even a petitioner. He submits that though that even that so far as the applicant number 2 is concerned, namely Sri Topon M. Price, though he was a petitioner in WPC 5660/2009, there is no statement that the applicant number 2 belonged to the scheduled tribe category. By drawing the attention of this court to the pleadings made in paragraph 28 of the writ petition,
27.
Huh?
27.
This is 27. Page 18.
Page 18.
Yes, paragraph 27 and 28, Sri Chutia, the learned Technical Council has submitted that only a general statement has been made regarding the application of the Reservation Act and the rule. Full stop. Para. Sri Chutia further submit that even overlooking the aforesaid aspect of the matter, the appointment order which was annexed to the writ petition. What is the date of the appointment order?
27/11/2009.
The appointment order dated 27
11/2009. Page 160.
dated 27 11 2009 would show that 17 persons were appointed against the 17 numbers of vacancies, full stop,
In order of merit.
which were in order of merit, full stop. To buttress his argument, attention of this court has also been drawn to the select list prepared, in which the position of the petitioner, of the applicant number 2, was 35, correct? 35. And there were a number of persons in the ST category above the petitioner who were also not appointed. He submits that in any case, the reservation being only 5% would have constituted one post, which would not give any relief to the applicant number 2.
and 3 person has already been appointed, belongs to ST Hills category.
He further submits that the advertisement in question had made it clear that the reservation rules policy would be followed, and in fact, 3 persons belonging to the reserved category of ST Hills
Yes.
were among the persons appointed. He submits that apart from the fact that the present application is not maintainable, no no fruitful purpose would be served. The petitioner would not be benefited in any way by, even if the review petition is allowed. The learned counsel for the private respondent have submitted, while endorsing the submissions made by the learned standing counsel of the council, have submitted that no fault can be attributed to their clients, in as much as their selection was done in accordance with merit, and in fact there is no allegation of any nature against their selection, and the challenge is only pertaining to the issue of following the reservation policy. Rejoining his submission, Sri Roy Chaudhary, the learned counsel for the applicant, has submitted that there were a number of writ petitions, and though only one writ petition has been mentioned in this review petition, since the judgment and order is a common one, the first objection may not be is not tenable. He submits that in any case, so far as the applicant number 2 is concerned, he was a petitioner in the concerned writ petition, and therefore it cannot be said that the review petition is not maintainable, more so when liberty was granted to the applicant by the Honorable Division Bench to prefer a review. Full stop. He has also drawn the attention of this court to the averments made in the affidavit in opposition of the council, dated 10/2/2010, wherein the allegation of not following the act in question have been admitted. The private submissions made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been examined. The power to access the power of review is to be exercised on extraordinary circumstances, and only if a case falls within the contours of the provisions laid down in the CPC. Full stop. In the instant case, the primary ground of review is that a point which was taken up in the writ petition was not considered by the learned single judge while disposing of the writ petition, disposing of the writ petition by the common judgment and order dated so and so. Sarah? It is a settled position of law that points urged, points taken in the pleadings, which, however, is not, which, however, does not specifically finds mention in the judgment, are deemed to have been considered and rejected. And under those circumstances, this court is not able to accede to the contention made on behalf of the applicants that the judgment and order in question is liable to be reviewed. Full stop. Even otherwise, this review, even otherwise, the facts and circumstances as narrated above are such that no case for review is made out and no fruitful purpose will be served, even if this court decides to rehear the petition, as the position of the applicant number 2 was 35 in the select list, and there were only 17 numbers of posts which were filled up. Full stop. This court has also noted the submission made on behalf of the council that there are persons above the petitioners who were also not given appointment, who were also not offered appointment and had belonged to the scheduled tribe category. Full stop. The standing council of the council has also submitted that amongst the candidates who were appointed, there were three numbers of candidates belonging to the ST Hills category. Full stop. Under those facts and circumstances, this court is of the opinion that no case for review is made out, accordingly, the same sense dismissed.
There is a judgment, my lord. In the judgment, it has been Supreme Court judgment, but there are definite limits of the exercise power of review. The power of review may be exercised on the discovery of new and important matter of evidence.
We'll put the judgment later. There's a latest judgment by Justice Honorable Justice H. Kohli, authored by her. All right. Review determines judgment by reference. Item. This is top of the list or what?
Top of the list.
There are one matter which is connected, where we had granted liberty to an Outstation Council to even to make a mention for upgradation.
Right.
Senior Council is here.
Right.
Now how to go about it? And these are matters which have come out of on a very different circumstance.
Right.
Madam, there is some development for which some matters have been specially entrusted to this.
I suggest one thing to Lordship.
We had thought that we'll give you 2 days and finish off this matter.
Yes, Lordship. I will take only about half an hour, 45 minutes. At the other side, your Lordship, if it's significant, take it, it's not at the time. I'm just seeing your Lordship's indulgence only for about half an hour, 45
We can have it then. If you can finish it by 1 hour,
Yes,
we can have it at 2 o'clock.
that would be.
How long Mr. Bhattakur will take it this matter?
It should not take much time.
And Mr. RKD Chaudhary is there?
Your Lordship sees this
court number rather than NIA matter, the Dayan has stopped. But my humble request to your lordships is that if Dayan is here, and I was not here when they were making their submissions, but the BP Council has adequately briefed me.
No, we'll hear you. We'll,
At 2 o'clock, if your
we'll,
lordship,
no, we hear you from the beginning. You may not be so elaborate, but we'll have to touch the point.
yes,
We heard
sir.
it long time
I-
back.
Yes, your lordships, because now I'm going to be very concise and I will give your lordships, I will not take more than 45. I will wind
okay.
it up within that.
If you're prepared in that way, then good.
We'll do it. At 2 o'clock,
Yes,
very quick.
not exactly at 2, maybe we'll see. We'll finish out this matter.
I'll be here at 2
Okay.
o'clock. Great.
I think we have heard this matter at some point of time.
At one point of time, your lordship.
Remember something when Mr. Das was narrating, we vaguely remembered something. And why did it go? Why is it remain pending now?
Was also heard by another bench subsequently, your lordship. Order was order.
But I think we had heard. We heard in 2019 January.
Lordship.
I thought 4 years. From 19 this bench is not given to bench 2, I think.
I was not there to raise
Yes.
when advertisement was put on 19th
For
or election and appointment to the post of principal in Alo Ali High School. The lordship will find that
on page
case 54.
54. One page. I think we have some earlier notes. We will try to improve. Advertisement when?
Advertisement on advertisement on 19th
19/6/2016. For
for the post of principal in Alo Ali High School.
Malu Ali.
The different name lordship now it has one. Actually, it's the name of the person. Alo Ali.
School at which place? Jorhat.
Jorhat.
Okay. You applied.
I applied. And the school selection committee was
You were otherwise working as what? Petition assistant teacher.
and the school
Applied.
I applied. And the school selection committee was constituted of I came no letter. Respondent number 6 against whom lordship I had 2 rounds of litigations earlier. That orders also I have an experience. She became a member secretary. And
RC?
I have taken 1 ground of that she will be biased against.
Was a member of school selection
She became
committee.
the member secretary of the school selection committee.
Member secretary.
Member. My 1 ground is that she will be biased against it because there are 2 rounds of litigations against her in respect of interest principal. Because I was much senior to her, but she was allowed to hold the charge of interest.
Okay.
The article of the panel has been prepared by the school selection committee, wherein lordship the petitioner has been given 11 marks, while the response number 6 has been given 12 marks. So also will find it at page 55 and extra
11, response number?
response number 6
Not
has been
6
given
is,
12,
6 is the selection committee member. Yes, sir.
no 5. Response number 5 is the become the member secretary. 6 the please input appointment has been
Then 5 is the member secretary.
member
R6 given 12 marks.
12 marks. I have been given 11 and one Sudhya Datta, he has been given 10. First, second, third.
Is he connected? Not to
Uh, Now
Yeah.
what you will find in page
When was this selection held?
selection, the interview that has been given here, lots of the date is 16/11/2000.
Okay.
And there is another statement of interview. Mark has been given under the head of leadership. Leadership skill of both the petitioner and the response number 6 has been given 5 marks out of 5. And in the category of administrative ability,
Leadership,
both have been given same marks, 3 out of 3.
administrative.
Administrative 3 and 3. Both 4 equal,
Leadership 5-5.
5, 5.
3-3.
3. And in the integrity and ACR losses, the response number 6 has been given 4 marks, while the petitioner has been given 3 marks.
Is your integrity. Okay.
So in respect of administrative ability, my contact, my ground taken that I have produced better credentials than the response
In the
number 6.
administrative,
Administrative.
both have been given the same
Both
marks.
of the given
3-3.
same marks. And in respect of the leadership skill of the kindly come to para 10.
First you address on the leadership, then you come to administrative.
Page 10 of my ticket. Here I have given a calculation. This mark to be given on the basis of a notification.
Page
Page 10.
10. Yes, 10 paragraph.
Paragraph 16.
Yes, what is there?
As per the notification of the PISA and as per notification, there is 7/6/2016, 51, page 51, mechanic 51, page 51,
7,
page 53, page 23/6/2000,
page 23, 6,
2006, page
53.
how the
Noti-
marks are to be allocated.
Notification giving guidelines.
Yes, guideline,
Guidelines for allotment of marks.
allotment of.
Yes.
So, this is the guideline. Leadership skill 5 marks based on the results of SSLC AM
53.
page 50.
Yes.
Of current year 2016 and last year 2015 of the school in which the person is working at present. The candidate will produce the results duly certified by the principal by where he is present. Now, in respect of leadership skills, now comes to page 10. I have made a calculation for the response number 6 is the subject teacher and her particular subject of the percentage in 2015 and 16 respectively is 36.84 and 19.5. The average is 64.7 and marks given is 5, but he is entitled to 3.23. And the petitioner is entitled to her percentage of passing out candidate is 73.80 and 72.3. So she deserves 3.61.
This is for leadership.
Leaders. But we have been given equal marks, 3 and 4 of
This leadership can be assessed in an objective manner.
Plus.
R6,
on the basis of the results of the
R6 should have 3.23.
actual
She should have got 3.23.
3.23. Marks given is 5.
And you?
Plus I deserve 3.61. I have been given 5. 5 out of 5.
Both have been given more.
Right. Just to put that in a better.
Okay.
And lordship, with regard to administrative lordship, this thing lordship, I have annexed in my all the annexes are here. That and lordship. Yep. And my contention is that I have submitted better credentials. I have worked as a research person. I have Bharat Science and batch certificate. All of it.
No. So far as leadership is concerned, you have demonstrated that the assessment can be done in an objective manner. Anybody can calculate. So far as the other two aspects are concerned, how do you make this?
That administrative
You said that there are three.
Yes.
Uh,
The notification says lordship based on the award honors begotten by the candidate school with students teachers in academic sports, sociocultural events organized in state or national level by any organized government. So even living at that part lordship, now coming to integrity and SCR lordship. There is no any adverse remark against me, no any disciplinary proceeding against me, but still in the
Integrity?
integrity and SCR lordship, the petitioner has been given 3 and the respondent number 6 has been given 4.
Petitioner
That has
3,
been
respondent 6.
4. Respondent number 6, 4, and the petitioner has been given
Yes, what do you say on this?
because there is no any adverse remark and lordship one more
Don't say no any.
one
There
more
is nothing
illegality
called no any. There is say no. There is no.
and one
What
more
is no any?
illegality is that lordship the SCR and integrity remark is to be given by the inspector of school. But in this case, lordship, the school president has given the mark. That is a
You say there is no adverse remark.
no adverse remark, and that
How is the marks given?
on the basis of the SCR last 8 years, and that is to be given by the inspector of school. But in the instant case, lordship, it has been given by the president of the school managing committee.
Given by IS. Yeah.
When this matter was taken up,
Given by president. How much was what was the mark on the ACR?
SCR lordship, the respondent number 6 given 4. I have been given 6.
No, that is the total mark. ACR, how many years the ACR?
The notification says
Excellent, excellent and outstanding 3, very good 2, good 1.
For 3 years. For
For-
three preceding years. How
for
many years?
excellent, outstanding 3 marks, for very good 2 marks, for good 1 mark.
No. How many years?
It will be lordship 2 because in respect of leadership skill, they have said 2015 and 16. So it should be prior to 2 years.
No, you take the ACRs for 1 year or 2 years and make the average. But normally in other selections, 4 years is taken or 3 years. Minimum 3 years taken.
Minimum 3 years, but in fact, lordship, in this case, maybe they have taken 2 years.
So what were your ACR markings?
SCR mark lordship, I have not been given SCR mark. My SCR is good. There is no any adverse.
No. What was the gradation in the ACR? Your
That I have not.
no. You said he said excellent or something.
Yes.
What was the ACR gradation? What was the assessment? We are not in the markings. Markings we can calculate.
That I have not.
Then from where can you say that only because there is lack of adverse remarks, your the score which you have secured is more than that of the respondent was taken?
During the interview, they have given me to understand that because I have filed 2 petitions earlier, that is why I have given
No, that may
1
be
mark.
correct factually, but to prove to demonstrate it's
And
absolutely
in fact,
difficult.
the record was placed before a lordship and record and the lordship has filed on 19/1/2019 lordship that the order of has been presented. How the SCR mark department of council was directed
Order
how the mark-
dated
on order to the lordship 19
19-1.
91 to the 9. Your lordship has recorded that after hearing matter at some section and after perusal of the record for section 45 the day data. Grant responsible of the secondary education department to direct the grant obtain as per marks under the column integrity and SCF have been allotted to the candidate. This direction after considering the fact that from the result of the record and the SCF in particular, it is found that both the victim and the respondent were given the remark very good for the relevant period in question and the case get part. Order there is no any adverse remark with regard to subpara 1.
Further there is,
Order is the 19th.
further there is,
Okay.
further there is, what you, right,
Further, there is no adverse remark with regard to
why did you insert the term any again? We have not written any. Don't use the expression no any. There is no such expression.
Oh, sorry. Further, there is no adverse remark with regard to subpara 1 and 2 under the column of namely earlier penalty and pending department. This is get
We had recorded that the marks at best would be equal.
equal. Your option is the next.
And if the marks are equal, how do you make the selection? That
I
is the
get one
case.
mark more. I get 1 mark more. That will be equal.
How, from where?
Integrity here I have been given 1 mark less than the response.
No. Assuming that we accept your argument, you will be at par
I will be at.
along with the respondent of 6. Then whom do you select?
Then also I have other rounds also. My next round will be also here is not right.
Okay.
Here the
If we accept your first submission, if you hold your marks to be at par with the respondent of 6, then you come to the second point that his BEd is he or her.
her.
Her BEd is not valid. So she is not even eligible.
And in the leadership also, Lordship, as per my calculation, we are given 5 out of 5 votes, but he is entitled to 3.50 and 3. I am entitled.
You are 3.161.
He is entitled to 3.23,
23.
and I am entitled to 3.61.
61.
The leadership skill also, Lordship, I score better than. And Lordship,
See,
in
it's a,
regard-
you are on totally on fact. Difficult to go in, but since you have also referred to an order of this court wherein we had seen the record and we had seen that the remarks given in your ACRs and the marks calculated, you will be at par.
Par.
Who is for the department? Mr. Sharma? You got the record? See, there are two issues. First issue we'll consider, but the second issue, your feedback would be very essential. The BEd part. Well, of course, we have not even heard Mr. Portakot. They'll defend. But what, as a department, what do you think about such a BEd degree? Records would be records I think it will be the director.
Director.
You get the record. We'll take this for disposal. In fact, will not leave this matter. We'll leave maybe next Tuesday. Well, how soon can you get? Day after tomorrow, is it possible? Day after tomorrow, is it possible, or next Tuesday? But this matter, as you know, is especially interested. We don't want to delay this matter. This way or that way, we have to finish it up. What do you have to say about your BEd degree?
Lordship, so far as my BEd degree is concerned, it is valid, and until and unless this degree is cancelled by someone, Your Lordship, and they have accepted it, the authorities accepted it, I have got increment against that, Your Lordship. Now, after
Is there any judicial pronouncement or any authorities order or notification holding that BEd obtained from the Bidhan? What is that institute? Is not valid in the eyes of law.
No, Your Lordship, I have not found. Rather, Your Lordship, I have one judgment, Your Lordship, which
No, see, Mr. Das, you have raised an allegation. We may accept, but till such pronouncement is made, only by your allegation that BEd is not valid.
I am not saying that our BEd is not valid, but our mode of obtaining the BA degree cannot be accepted by the faculty because he was a regular student in the school, he was attending classes. And
See,
from
validity of the
Jorhat
degree,
to Dorong, it was a 350-kilometer distance. As per Assam Services Conduct Rules, he take permission from the competent authority while pursuing. And department has already nullified various degrees on the basis of that particular rule of the Assam Services Conduct Rule. He has not obtained permission, and I have obtained those records from RTL.
this is not a distance, this is not a distance motor.
Not. He was a regular student in Jorhat and he attended classes in Deomono, that is in Doron district. 350-kilometer.
Explanation?
Lordship, so far as your lordship, that part is concerned, your lordship, that instruction right now I don't have, your lordship. I will take, your lordship. And secondly, your lordship, even assuming your lordship accepting his argument, your lordship, what he has stated, your lordship, my case will be, your lordship, that since this has been accepted by the authority and there is no challenge to that, your lordship, that degree,
One individual cannot question.
Lord, until and unless it is for the authority, your lordship. The moment they decide to cancel, then I am out, your lordship. But till that date, this will have to be considered, your lordship. Even if it is wrong, your lordship, that will have to be decided by the authority.
You had a fast car.
Fastest.
Fast car. Not fastest. You had Tracy Chapman driving the car. Jorhat to
Dorong.
Mongol.
Mongol. At that time, Kaziranga restriction was not.
Not there.
Okay, Mr. Sharma, how soon? Thursday, day after tomorrow, or Tuesday?
Tuesday, your lordship.
But bring it on Tuesday without fail. The whole matter not doesn't look good to keep it pending. For three, Askeda, current counsel for the petition, whereas three, U Sharma has represented the department, concerned department of higher education, secondary education. Court of three, as Kothapur has appeared for the response number 6. Anyone for 5? 5, anyone? No.
No one has.
3, Das has referred to an order of this court, an earlier of this court dated 19/1/19, as per which which reflects that records were also produced. The state records, however, are not readily available with the Lieutenant Counsel of the Department today. And according to Sri Sharma, praised for some time. Considering that this matter is pending since the year 2017 and has been specially listed, in the interest of justice, the hearing is deferred to Tuesday night, to 30th, 30th of May 2023, on which date Sri Sharma would positively obtain the record. Let a copy of this order be served upon Sri Sharma to enable him to do the needful.
But were already admitted for hearing. It was listed for hearing on the occasion. Latest status is that state respondents were ready to reconstruct.
Item number?
Lordship, this matter, these two matters, Lordship, the record was, Lordship, I filed my affidavit on 15/3/2023. they, my lord, we were directed to reconstruct the record. And my lord, accordingly, my lord, today, just while back, my lord, I have received the record. We'll have to go through, my lord, whether the record is up to the mark, my lord, my lord. Therefore, my lord,
There are two matters, Mr.
two
Pugasta.
matters, my lord. Matter, my lord, pertains to the, they have challenged the gradation list, my lord. They find anomalies in the gradation list of the Kachar district.
For the post house,
Head
Head-
teacher in the
head-
MES,
Head teacher.
entire process.
So, my lord, we had submitted, my lord, in my affidavit, it's already been reflected in the affidavit that the record was submitted to the court. Later on, it was not returned back. There was a confusion regarding that. Therefore,
have you got the records now?
we have reconstructed with the photocopy. We have given the photocopy of the record to the back to the department. But the main record is not found.
There is the order, Lordship. Order
There is an order, my lord. And
Now, whatever materials we have, we'll proceed with that.
my lord,
Proceed,
my lord
Right,
will,
Lordship, as it was already for hearing. It may be posted for hearing.
no, we can have it today. What is the difficulty?
no, today, my lord, it will be difficult because records have been received today. My lord, we have to go through the record.
Oh,
Arvinder will be
okay,
appearing,
then we'll
and my
have it day
lord,
after tomorrow.
there might be a need. There
Day
might
after
be,
tomorrow.
no, there might be a need that we might need to file an affidavit. Your lordship kindly see the
17 matter, what affidavit will file now?
no,
We'll
my lord.
decide.
What had happened was a record was produced. My lord, if your lordship checks the
No, that part we'll take care.
that affidavit was filed, and my lord, that record was given to the my lord. My lordship is
That
the
affidavit is part of the record, is the part of the court file.
is yes, my lord. The file,
Then why to worry?
my lord, no, my lord, the record will be required. The record will be required. The record was missing. My lord. Therefore, we had filed this
Mr.
affidavit.
Pukan, you have said that records were missing. You have reconstructed the record.
Yes, my lord.
We will accept that. We will not look for the original records. Your affidavit may not be necessary. You come prepared day after tomorrow.
Right.
Oh. Third, as the broadcast has been accounted for the petitioners, whereas the Elementary Education Department is represented by Standing Council Sri A. Pukan. Sri Pukan has submitted that the original records were misplaced in the court and thereafter reconstructions were done.
We handed over to the court. My lord. Later, we didn't get it.
The original records were handed over to the court, which was thereafter misplaced,
My lord,
for which the records had to be reconstructed.
Right.
He reconstructed and have been handed over to him only today. He accordingly prays for some accommodation. Full stop. Sarah, considering that these are long pending matters, please for admission hearing. Day after tomorrow. Issue is of a gradation list.
my lord.
Process of promise.
And also, my lord, there are a lot of issues regarding maintainability also, whether the petition is maintainable or not. What do we?
You wanted us to take note with regard to the representation which was submitted. Sir, I confirmed from the authorities, sir. This representation was never been submitted before the authorities. In fact, from the representation also, it is clear, my lord, page 36 is the original copy.
There is no receipt.
There is no receipt. Sir.
You're still there.
And in our record also, we have not found. And moreover, my lord, apart from that, my lord, these documents was a mandatory document which has to be uploaded. Now, the petitioner has uploaded the earlier mark sheet, not the betterment. And based on the earlier mark sheet, marks was awarded. So as this was not before the authorities, there was no wrong on the part of the authorities. And my lord, Lordship has seen, my lord, in all these days, there are many cases which are coming, my lord, because they have not submitted the required document. And the advertisement makes it very clear, my lord. There is a point in the advertisement that
No, we are on a different. Assuming that this thing was offered as a matter of fact, there is a document from which, if the marks are deduced, he is on a better footing, he or she. Now, you are going ahead with the appointment tomorrow. If a person who is below his rank, maybe he is at fault. He or she is at fault for not giving the original. But As a matter of fact, his position should have been, her position should have been above the last candidate or whoever. Is it possible to leave, to retain one vacancy?
Look, at this stage, my lord, reserving one vacancy, my lord, may prejudice the entire selection. So we are
Just now
publishing.
my friend has said that there will be many more vacancies.
Yes.
Many more vacancies.
Therefore, my lord, instead of saying that, my lord, the lordship will record my submission, my lord. There will be vacancies, my lord. If they succeed in the repetition, my lord, we can accommodate.
Well, after 5 years, my lord, that cannot be.
No, we'll bring it on affidavit, my lord. This
Right.
within
So
a
one day, we do one thing.
One
We do one thing. What we are suggesting, if this matter can be internally resolved, since this, they have denied your claim that you have submitted a representation. In fact, the representation doesn't have any receipt. We give you liberty to approach the authority within 3 days, and they will not non-suit you only because you have not come in time. We'll say you consider and give the original thing, and whatever
based on the
vacancy
merits.
is there, you'll be accommodated if you are within that.
Based on the merits, my
We can dispose this of
my
it.
lord. Yes.
First, we take care of Chaudhary when it counsel for the petition. Also heard. The B Caustic,
My lord, I'm to respond both
the Learned Training Council,
elementary.
Elementary Education Department, representing all the respondents,
All the respect.
para, considering the nature of the grievance and the attending facts and circumstances from this matter is taken up for disposal at the motion stage. In fact, when this matter was called up in the first half, this court had directed the Learned Training Council to obtain instruction and has been called again in the second half when he is equipped with instructions. The matter pertains to a selection process for the post of assistant teacher in various
LP and upper primary.
LP and upper primary schools in the state of Assam. Without going into the detailed facts, the grievance is with regard to the assessment of marks. The case of the petitioner is that the marks are the evaluation is done by an objective by following objective criteria, and marks are deduced from the various from the marks obtained by the candidate in various examinations, starting from matriculation.
Higher secondary.
Hmm?
Higher secondary.
Where is the notification?
Page 22. At relevant page is at page 25.
Starting from
Clause number
Distribution at page
23.
25.
starting from higher secondary.
Yes, it's not right.
Full stop. The specific case of the petitioner is that he had appeared in a betterment examination of the higher secondary. And there was an improvement by
6%.
by 6%. Full stop. In fact, he has annexed the
Page 19.
the mark sheet pertaining to the betterment examination, wherein there was increase in the marks obtained in the subject of English within inverted commas from 38 to 68, while there was a decrease in the subject of economics from 49 to 46. Full stop. However, there was an overall increase by 27 marks.
So it was previously it was 38. Now it has gone up to 68, 20 marks. It has been reduced 27.
27.
27.
By 27 marks. The contention of the petitioner is that the marks obtained after the betterment examination have not been taken into consideration, as a result of which the assessment has not been properly done. Full stop. The learned counsel further submits that in consonance with the rules, the petitioner has also filed a representation before the director on 5/5/2023, which is also yet to be taken into consideration. Full stop. Para. On the other hand, Sri B. Kaushik, the learned standing counsel of the department, has submitted that it was mandatory upon all the candidates to submit the necessary documents, and if the petitioner was actually taking recourse to the betterment mark, the relevant mark sheet should have been submitted, which was not done. Full stop. He further submits that there is no specific averment that the mark sheet of the betterment examination was submitted. Full stop. He accordingly submits that since the mark sheet of the petitioner pertaining to her performance in the higher secondary examination held on 2011 was only before the authorities, no fault can be attributed in making the assessment. Full stop. The understanding counsel further submits that he has specific instructions that though a copy of the representation said to have been submitted by the petitioner is annexed to the writ petition, no such representation was actually received by the office of the director. And he also points out that in the annexure to the writ petition, there is no endorsement of receipt of the said representation. The standing counsel, however, fairly submits that over and above the present vacancies, there would be further appointments as more vacancies are likely to come up. Full stop. Para. 3. P.K. Roy Chaudhary, Sri Roy Chaudhary, learned counsel for the petitioner, submit that since there is an internal mechanism for redressal of grievance, and since a submission has been made by the department that the representation was not received, comma, he may be given liberty to submit a fresh copy of the representation. Also, he further praised for a direction that in the event a fair assessment is done and the petitioner is held entitled for such appointment, comma, he may be accommodated in any vacancy, if any vacancy which may be existing. Full stop. Full stop. After hearing the parties and on receipt of the and on perusal of the materials before this court, comma, this writ petition is disposed of. Now, this court is of the view that if the averment made by the petitioner regarding the marks secured in the betterment is correct, comma, the petitioner would be entitled to have an assessment. Full stop. At the same time, this fault cannot attribute any fault. This court cannot attribute any fault upon the authorities, as it has been categorically stated that the mark sheet pertaining to the betterment examination was never before the authority, and there is no reason as to why the marks entitled by a candidate would be deprived, would not be considered full stop. Under those circumstances, comma, this court gives liberty to the petition to submit a fresh copy of the representation within to the Director Elementary Education as per the notification itself within a period of 3 days from today, which is directed to be considered full stop. It is made clear that the representation is required to be considered on merits by merits and the aspect of delay in filing the representation should not come into the way of such consideration. Full stop.
Along with the petition, I may be allowed to, if not, submit the betterment part.
Obviously,
That also.
it is needless to say that along with the representation, comma, the petitioner would annex the mark sheet, all the documents, including the mark sheet of the betterment examination, and also have the original in hand for ready verification. Full stop. If on such consideration, comma, the petitioner, the mark secured by the petitioner is found to be within the cutoff, comma, she would be offered an appointment in any existing vacancy, in any vacancy which may be existing or would occur in near future, which has been submitted by the learned counsel for the department. Petition economic sense disposed of. That you need not make, you'll get it.
All right.
surprised your conscious how I'll
Hold on a second. Hmm? One minute.
must have also keep that handy the affidavit which has been filed by my government friend, the last affidavit.
I think that's a part of the record.
Yes, sir. So that can be kept handy.
Yes, please proceed.
Before our part, it had
But I would like to finish it today.
Yes.
It's not taking much time. 1 hour.
that in case of the article 79 to 91. Yes, going on.
We'll try.
This apply to Dr. Power. This additional affidavit has been filed by my learning friend.
Right. Additional
February this month, your lordship said it's page number 2000 onwards. Your lordship, the opinions are referred only to this in
Page
terms of
number.
2000. In writ petition 270 of 20. Your lordship said this date, your lordship petition. The last occasion when I was arguing.
Photocopy to. When did you file this? Who has filed it? Ryan has filed. When was it filed?
February.
Please, please, please. I think I presented a list of dates.
Yes, we are
There is not there.
on the last occasion.
I know we remember
argued
going
from
by
that.
that.
Yes,
Yes. We had made note from that.
we might have we have made the facts for
Yes,
the
yes, yes,
law.
yes, yes.
Is the matter which an FIR was lodged on 26/4/2013 under sections 124 and by the office of the governor of Meghalaya against the university, its vice chancellor and other officers. The sum total of allegations that your lordships were two. One, institutions were running in collaboration with us, thereby resulting into an illegality in as much as that is not permissible under law or the Supreme Court's judgment of Professor Yashpal. These are the two main allegations of the FIR. Actually, Your Lordship, they said there were thousands of mark sheets, there were thousands of provisional certificates, they did not have the wherewithal. And one of the limbs of the facts which they have tried to depict, Your Lordships, is that we were running a university from a tin shed. We did not have a proper campus, and therefore we could not have enrolled as many students and issued as many degrees. On basis of that FIR, Your Lordships and Lordships will recollect that this was the case where we had requested the governor, who's the visitor of the university, because we are constituted under a state statute, we are regulated by UGC, and under the provisions of the statute, the visitor has to appoint the vice chancellor, and on our recommendation, if the appointment is not done within a particular time,
Governor is called the visitor,
he is the visitor.
not the chancellor.
No, he is the visitor. And we have to appoint a vice chancellor. Our
You don't have the concept of chancellor.
No, Your Lordship. We have visitor and vice chancellor. And the vice chancellor recommendation has to go from the board to the visitor, and the visitor has to ratify that. If the visitor does not ratify it within a particular period, then it is deemed to have been ratified. Unfortunately, some unpleasantness followed between the vice chancellor and
You
the
want to
visitor.
portray that the channel has to go from the VC to the visitor, not otherwise.
Yes, Your Lord. It has to be recommended by us unless there is an objection that normally gets accepted. That's how most universities
Yes,
are. Your
that is
Lord.
the function.
Yeah, that's the general method which they operate. Unfortunately, there was some unpleasantness that followed between the two personalities. And therefore, the visitor did not grant sanction for the appointment of the vice chancellor. And he has not refused it either. So there is no refusal. So as such, the procedure under law takes place, and the vice chancellor's appointment gets legalized. Thereafter,
The appointment of the VC itself was not sanctioned, was not approved.
no, Your Lordship, not
Hello.
approved, but under law. but under law it is deemed to be a plea. Nevertheless, since this friction was continuing, on basis of this FIR, a charge sheet being charge sheet number 1 of 2015 was filed on 20th of April 2015.
Yes.
On basis of this charge sheet, your lordships,
Charge sheet is pertaining to 26/4/13 FIR.
yes, your lordships, that is in the predicate offense, charge sheet in the predicate offense. On basis of
Till then PMLA did not come in.
no, your lordship, on basis of this charge sheet, because at that time the law was that only after the charge sheet is filed. Once the charge sheet is filed, your lordships, the PMLA ECRs are registered on 7/7/2014. And these are 4 in number, various officers and the university, but the content of this of all of them are the same. In terms of quantum, in the FIR, there is an allegation that 83 crores of rupees is the income of the university at that time when the FIR is lodged and seizures are made.
In 13.
Yes, Your
13.
Lordship. Yes, Your Lordship. So on that particular day when the seizures are made, approximately 83 crores is on the credit side of the university. However, with regard to the 2 allegations, firstly, with regard to the MOUs with third parties outside Shillong, the allegation is only with regard to 9.6 crore.
For off center.
Yes, for offset. And as far as the degrees are concerned, fake degrees are concerned, and specifically the PhD degrees, there is no quantification. There is a bold allegation that the entire credit statement of the university on that particular day is pursuant to criminal activity. On basis of this charge sheet, the PMLA ECIRs get registered, and prior to the registration of PMLA ECIRs, 43 crores approximately, I'm giving just the ballpark figures, your lordships will recollect them, then the exact figures will come on the record. 43 crores is said to be seized by CID.
CIG.
Yes, sir. And under CRPC, under the CID code, we moved several applications because we are an ongoing university. We need to withdraw certain sums. Release or and decreasing of certain amounts is given from time to time. And by the time, your lordships, an order dated 13/10/2015 is passed by the trial court, which allows the release of 15.62 crores.
Release of
15.62 crores. Therefore, when the PMLA proceedings begin and the attachment is made, the residual amount is about 27 crores. And that is what is sought to be attached under the impugned orders. And this is the impugned order in the first writ petition.
Yes.
In the meanwhile, your lordships, we make applications for withdrawal of money which are challenged by the state, your lordships, that the Honorable Supreme Court passes an order saying to redeposit the said 15.62 crores which you have withdrawn, to redeposit and make fresh applications for withdrawal. And these amounts, your lordships, are in form of FDs, of overdrafts, of our bank accounts, of securities. So there are several methods by which this amount is deposited and frozen. So for the purposes of redepositing 50.62 crores, we execute fresh FDs. And those FDs are generated from loans which we have to take because we have no resources at this point of time. So we take loans against other properties and deposit fresh FDs which have fresh new numbers obviously to them.
Yes.
So lordships will just keep this fact in mind because one of their allegations is that we are doing a money chain whereby we are swapping various securities, etc. And therefore, they say that you have violated the order because you have not redeposited the same generated your lordship. So this is one of their allegations. After that, your lordships, what happens is that as of now, they
Your statement that you have taken loan for the FDs, those are substantiated.
yes, your lordship. In fact, what we do, because they keep on opposing it, they keep on saying there is contempt. Supreme Court rejects their contempt application, says no, they have deposited. We cause the trial court to do an inquiry as to the funds are really lying with the banks or not.
No. We are on the issue of taking of loans. How to substantiate it?
Yes, your lordship. Against our other properties, private properties.
You have placed it before the trial court.
Trial court has it, and in fact, trial court certifies on an inquiry because they keep on saying that this is moving the money in circles. So we caused the trial court to do an inquiry on this very fact, and I will show that order to your lordships. The trial court has certified that these monies are lying in the banks. And I will tender it right away to your lordship. So your lordships, this is a certification dated 2018. And if I could just show the queries, your lordships. This is a query from the Superintendent of Police to the branch manager of Punjab National Bank. With reference to above cited subject, please find enclosed copy of Honorable Court order dated above. In this connection, you are requested to furnish the following: whether CMJ University or CMJ Foundation has made any deposits of 15.10 crores as per certificate issued by a bank to CMJ Foundation dated 24/3/2017. If so, please furnish along with account numbers, date of deposit and maturity, and also amount deposited and maturity. Please also verify whether amounts deposited are in the accounts as per honorable list of decreed account order dated so and so, and at date so and so, also honorable Supreme Court order dated so and so. And if your lordships will turn to the order dated 24/10/2018. In this, your lordships, on the second page, lordships will see the account numbers and the certification. May I just read this order, your lordship? IO is present in person and submitted that in view of order dated 7/8/2018, he had written a letter to Punjab National Bank, and on 19/9/2018, and he had received a reply from the Chief Manager of Punjab National Bank, whereby he had confirmed that CMJ Foundation, customer ID so and so, had made the deposit in shape of FDRs of 3.10 crores
only being maintained in their branch office, Greater Kailash, and he also informed that they had already issued a letter of confirmation dated so and so, confirming the genuineness of the certificate. Further, it is also submitted that the bank has also submitted that majority and substantial amount mentioned in the list are fixed deposit. Hence, no bank would have allowed to reopen and reassign the same FD account once the customer has encashed or realized the same whether on maturity or not. He also submitted that he has also engrossed copy of letter dated so and so and details of FDRs, Sugam deposit account so and so, CFD Foundation with PNB Greater Kailash. Further, the IO also submitted at this juncture, he has no objection. If stay order is modified to the extent that the opposite party may be allowed to withdraw the amount deposited by them in fixed deposits which they have deposited as follows. So this is
This is the no objection by the IO.
by the IO. So their allegation, in fact, in their affidavit, they say that we've been taking all the courts for a ride, but they don't put these orders on record, and they don't show to your lordships that they themselves have consented to the withdrawal of this amount. And then your lordships, the amounts are given in a chart form. Further, the IO submitted that opposite party may also give an undertaking that in case the instant criminal petition is decided in favor of the petitioner, the opposite party shall deposit back all the amount withdrawn by them. Counsel for opposite party agreed to the submission made by IO and stated that he would give an undertaking as required by IO and further submitted that the respondent will withdraw only the amount deposited as mentioned by the IO in the MOU. Your lordship will see that their allegation again and again that I have not redeposited 50 crores is false as verified by the bank, by the Honorable Trial Court. And it is a false allegation which is being leveled against me throughout the proceedings. Number one. Number two, your lordships, as far as these proceedings are concerned, the object of PMLA proceedings is to ensure that the proceeds of crime is but as far as PMLA is concerned,
You said objective of the PML.
objective of PMLA, your lordships, is that foods of a poisonous tree should not be enjoyed by the person who has planted the poisons. Therefore, if there are proceeds of crime, then those proceeds cannot be enjoyed by the person who has committed the crime and must be attached, and a fresh offense takes place if you utilize the proceeds of crime or you try to hide them and transform them into legal money. The money generated from illegal activities, illegal criminal activities, cannot be further allowed to come into the economy. That is the sum total of the objective of PMLA. And in fact, the provisions are extremely draconian. And in Vijay Mohanlal, the Constitutional Bench has interpreted the entire scheme of the enactment and have come to few conclusions. Those conclusions are that there are sufficient, number one, that there are sufficient safeguards in the enactment itself so as not to make it unconstitutional, number one. Number two, that the biggest safeguard is the definition of proceeds of crime under Section 2U, read with Section 3 and Section 5. And it has been very clearly said
that unless the ingredients are strictly satisfied and there is a connection which is shown between the proceeds and the crime, the money cannot be attached or the properties or the proceeds cannot be attached in whatever form that they may. And I'll read those portions, Your Lordship. So a
Yes.
very
Yes.
reason. And I'll show two judgments in reference to this, Your Lordships, which are now the most two recent judgments. One, Your Lordships, is of the Gujarat High Court. This is extremely
Yes.
recent, so we could not find it earlier. This is a case where the allegation is of 1,747 crores,
Well spun deal.
well spun crores. And the allegation in this, Your Lordships, is that when a company went into liquidation, State Bank of India alleged that the use of the loan money, which was taken by the original debtor, was utilized for other purposes except for which the loan was sanctioned, and therefore there was criminal act. So an FIR gets registered. Thereafter, there are liquidation proceedings under the IBC Act, and in the liquidation proceedings, petitioner buys the auction property, and that comes to his account. The allegation against this entity was because the money was relatable to that predicate crime, which SBI was the complainant. Therefore, these properties were also liable to be attached. And the value of these properties were 747. What the Honorable High Court said, firstly, Your Lordships, that the definition of proceeds of crime under Section 2, read with Section 3, is a very strict and narrow definition. So there has to be a nexus, direct or indirect, which has to exist, number one. And number two, it has to be shown that the authority had reason to believe that not only is this proceeds of crime, secondly, that I am going to transfer them so as to ensure that the same do not remain in the same form as the proceeds of crime. So this twin condition has to be satisfied. And finally, the High Court has quashed the PMLA proceedings against this party. Now, Your Lordship, I'll just
Isn't there a distinction that in the Gujarat case, the petitioner was a person who had purchased the property?
yes, Your Lordship.
How can, even if you assume that those are proceeds of crime,
Yes, Your Lordship. I
he
am
purchased in an auction proceeding?
Yes, Your Lordship. I bow down to that question. In fact, I am drawing Your Lordship's attention to the observations of this judgment.
No, first, your contention
Yes.
that it has to be proceeds of a crime.
Yes, sir.
The definition being a narrow, we can perhaps accept that.
Yes, sir.
But here I think there's a big distinction because the
Your Lordship, because additionally what has been said is that the observations in Vijay Mohan Lal, Your Lordship, are observed. And in this, because in Vijay Mohan Lal, what has been said is that you may be in possession of certain unexplained assets, but that does not mean that they are connected to the proceeds of crime. In my case, I am saying at best 9.6 crores with regard to my MOUs with offsetters,
You are emphasizing on the nexus between the proceeds of crime
Yes, Your Lordship.
and the offense which is registered
Yes,
under
Your
PML.
And proportionality, because now a line of judgments have come where they say that you cannot attach amounts larger than what which are connected to the crime. So your lordship will turn to paragraph 6.3 of this judgment.
Gujrat judgment.
Yes, your lordships, internal page 36. Your lordship, the relevant portions of Vijay Mohan Lal are already extracted here, so I will not read that judgment again. Because today this is the judgment which holds me.
Yes.
The lordship succeeds para 6.3 Vijay Mohan Lal Chaudhary for the case where the apex court was considering a batch of appeals concerning the validity and interpretation of certain provisions of PMLA. Relevant paras read as a para 2. The other relevant definition is proceeds of crime in section 212 of the 2002 Act. This definition is common to all actions under the Act, namely attachment, adjudication, and confiscation, being civil in nature, as well as prosecution of criminal action. The original provision prior to the amendment by Finance Act 2015 and Finance Act 2019 took within its sweep any property mentioned in section 1.5 of the Act derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense mentioned in section 2.1 read with schedule to the Act, or the value of such property. By Finance Act 2015 and further included such property being the proceeds of crime which is taken or held outside the country, then the property equivalent in value held within the country, and by further amendment by Act 13 of 2018. It also added property which is abroad. By further amendment of 2019, explanation has been added, which is obviously a clarification amendment. That is evident from the plain language of the inserted explanation itself. The fact that it also includes any property which may be directly or indirectly be derived as a result of criminal activity relatable to the scheduled offense does not transcend beyond the original provision. In that the word relating to, associated with, has to do with, used in the main provision is a present participle of the word relate, and the word relatable is only an adjective. The thrust of the original provision itself is to indicate that any property is derived or obtained directly or indirectly as a result of criminal activity concerning the scheduled offense, the same be regarded as proceeds of crime. In other words, property in whatever form mentioned in section 1B is or can be linked to criminal activity relating to or relatable to scheduled offense must be regarded as proceeds of crime for the purpose of 2002 Act. It must follow that the explanation inserted in 2019 is merely clarificatory and restatement of the position emerging from the principal provision of section 212. The proceeds of crime being the core of the ingredients constituting the offense of money laundering, that expression needs to be construed strictly. In that, all properties recovered or attached by the investigating agency in connection with criminal activity relating to a scheduled offense under the general law cannot be regarded as proceeds of crime. If your lordship can kindly underline this, a very important paragraph, your lordship, because the limiting contours have been drawn here. There may be cases where the property involved in the commission of scheduled offense attached by the investigating agency dealing with that offense cannot be wholly or partly regarded as proceeds of crime within the meaning of section 12 of the 2002 Act, so long as the whole or some portion of the property has been derived or obtained by any person as a result of criminal activity relating to the scheduled offense. To be proceeds of crime, therefore, the property must be derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offense. So that live link is a mandatory requirement. To put it differently, the vehicle used in the commission of scheduled offense may be attached as property in the concerned case it may not be proceeds of crime within the meaning of Section 21 of 2002 Act. Similarly, possession of unaccounted property acquired by legal means may be actionable for tax violation and yet will not be regarded as proceeds of crime unless the concerned tax legislation prescribes such violation as an offense and such offense is included in the schedule of 2002 Act. For being regarded as proceeds of crime, the property associated with scheduled offense must have been derived or obtained by a person as a result of criminal activity relating to the concerned scheduled offense. This distinction must be borne in mind while reckoning any property referred to in the scheduled offense as proceeds of crime for the purpose of the 2000 Act. Dealing with proceeds of crime by way of any process or activity constitutes offense of money laundering under Section 3 of the Act. Be it noted that definition clause includes any property derived or obtained indirectly as well. This is what they rely on indirectly, but I'll just read further. This would include property derived or obtained from the sale proceeds, or in a given case in lieu of, or in exchange of the property, which has been directly derived or obtained as a result of criminal activity related to a scheduled offense. If I may just stop here for a moment. This clearly shows that the live link that crime A committed, whatever has been attached, has to be related to it. So suppose I have given 600 fake degrees. The fees that I have received from those 600 degrees, maybe I may have got some capitation money also, that capitation money. So that has to be identified and relatable to it, which can be attached, not my entire income of the university. And this Constitution Bench judgment makes it very clear that the link has to be direct, and indirect means that there has to be a further conversion. That trail continues. So once you have identified 600 degrees, this much fees with regard to it, say 1 crore of rupees was taken. I have converted that 1 crore of rupees. Suppose I get capitation fee in cash. I have converted that 1 crore into a fixed deposit which I have put into the university. That can be taken, that can be attached, but not what I have earned from undergrad courses, what I have earned from courses which are recognized, seats are sanctioned by the authorities, UGC accepts it, state government sends its students on scholarship to my office. All those cannot be attached. So this is the import of this part of this Constitution Bench judgment. If I can read further, in the context of explanation added in 2019, the definition of expression, proceeds of crime, it would inevitably include other property which may not have been derived or obtained as a result of any criminal activity relatable to the schedule of. As noticed from the definition, it essentially refers to any property including abroad, derived or obtained directly or indirectly. Explanation added in 2019 in no way travels beyond the intent of tracking and reaching up to the property derived or obtained directly or indirectly as a result of criminal activity made to the schedule of crime. Now, your lordships, the last line, it is re-emphasis of the same concept, the last line of this paragraph. Such purposive interpretation would be necessary to uphold the purposes and objects of the enactment of 2002 Act. Para 250. Tersely put, it is only such property which is derived or obtained directly or indirectly as a result of criminal act relating to the scheduled crime that can be regarded as proceeds of crime. Authorities under 2002 Act cannot resort to action against any person for money laundering on an assumption that the property recovered by them must be proceeds of crime and that a scheduled offense has been committed unless the same is registered with the jurisdictional police or pending inquiry by way of complaint before the competent forum. For the expression derived or obtained is indicative of criminal activity related to a scheduled offense already accomplished. Similarly, in the event the person named in the criminal activity relating to the scheduled offense is finally absolved by a court of a competent jurisdiction owing to an order of discharge, acquittal, or because of quashing of criminal case, that is of the scheduled offense against him or her, there can be no action for money laundering against such a person or person claiming to him in relation to property linked to the stated scheduled offense. This interpretation alone can be countenance of the basis of provisions of the 2000 Act, in particular Section 2(1) you read with Section 3. Taking any other view would be rewriting from these provisions and discarding the express language of definition clause proceeds of crime as it obtains as of now. Be it noted that the authority of authorized officer under Section
These are all quotation of Mohanlal.
Yes, Your Lordship. This is all the Constitution that I'm reading from that. Be it noted that the authority of the authorized officer under the 2002 Act to prosecute a person for offence of money laundering gets triggered only if there exists proceeds of crime within the meaning of Section 1 of the 2000 Act, and further is involved in any process or activity. Not even in a case of existence of undisclosed income, and irrespective of its volume, the definition of proceeds of crime under Section 2(1) will get attracted unless the property has been derived or obtained as a result of criminal activity relating to the schedule of. It's the same reiteration, Your Lordships. Now, para 283. Even though the 2002 Act is complete code in itself, it is only in respect of matters connected with offence of money laundering, and that existence of proceeds of crime within the meaning of Section 1 of the Act is quintessential. Absent existence of proceeds of crime as aforesaid, the authorities under 2002 Act cannot step in or initiate any prosecution. Now, this is very important because my case also hinges on the fact that there was no reason to believe for the authorities to proceed against, which is a mandatory ingredient of Section 3 and Section 5. This paragraph is very important, Your Lordships. In other words, the authority under the 2002 Act is to prosecute a person for offence of money laundering only if it has the reason to believe, which is required to be recorded in writing, that the person is in possession of proceeds of crime. Only if that belief is further supported by tangible and credible evidence indicative of involvement of the person concerned in any process or activity connected with the proceeds of crime, action under the Act can be taken forward for attachment and confiscation of proceeds of crime, and until vesting thereof in the central government, such process is initiated would be a standalone process. Then it goes on with regard to Section 5, Your Lordships. And I will just draw your attention, Your
What
Lordship.
about the expression reason to believe?
Reason to believe, Your Lordships, is a part of Section 5, which gives them the authority to proceed against. And Section.
What are the factors which constitute reasons to believe?
Yes, Your Lordships. So, reason to believe has to be factual, number one, tangible, number two. Therefore, first of all, they have to have reason to believe that I have committed a crime, first ingredient. That reason to believe exists on the basis of the FIR and the charge sheet which has already been filed. So that reason to believe is satisfied. The second reason that they have to believe is that I am in possession of that property, and X property is the property which is a proceed of that particular crime. So the identification of the proceeds and the reason to believe that this is the property, this is the piece which is relatable to those fake degrees, is to be told by them, has to be given in writing to while attaching that property. And it is not only with regard to attachment, also under Section 17 at time of searches and seizure. So I'll show to Your Lordships, Calcutta High Court has also interpreted as to where the reason to believe will operate. So it operates at every stage. Your Lordship, like one of the lines that we read was that reason to believe is a common thread that runs through the entire enactment. So even at the stage when they go for searches and seizures, they have to record that reason under Section 17. And Calcutta High Court, on basis of violation of that section 17 ingredient, has also quashed another proceeding.
PML proceeding.
PMLA, I'll show. So that reason to believe, now the second aspect of that is that identification of the proceed of crime. So they have to identify that 1 crore is what is relatable to your fake degree. For them to vaguely say that all the proceeds that you have got at the university, which you have generated by legal means, by running recognized courses, are all relatable to that offense, is something which is not provided under the law. And it being a draconian law, Constitution Bench has read in the limitations. The third stage where the reason to believe has to be there, your lordships, is that I am going to change the nature and convert those proceeds of crime into legal money, and therefore I am laundering that money. So the component of laundering comes third. So these three things, your lordship, section 5, may I just for a moment show section 5 again. Section 5(1).
Yes.
I'll just quickly read section 5, your lordship. Where the director or any other officer not below the rank of deputy director authorized the director for the purpose of this section has reason to believe, the reason for such belief to be recorded in writing on the basis of material in his possession, that A, any person is in possession of any proceeds of crime. That's the first ingredient. And the second ingredient is in conjunction. And B, such proceeds of crime are likely to be conceived, transferred, or dealt with in any manner which may result in frustrating any proceedings related to confiscation of such proceeds of crime under this chapter. He may, by order in writing, provisionally attach such property for a period not exceeding 100 days. So the twin conditions, your lordships, condition A is identification, and that identification on basis of materials has to be particular to the crime, connected to the offense, because reading in section 1U, the definition of proceeds of crime. And secondly, that I am going to be converting it and laundering it into legal proceeds. So this twin condition has now been held to be mandatory. And this mandatory aspect safeguard, otherwise it will be struck down under violative of Article 21. This mandatory procedure is the safeguard and the guardrail that is provided to uphold the constitutional validity of this provision. So your lordships will see that in paragraph 86 at page 46. And your lordship will kindly see that what is the, just before I go to paragraph 86 at page 46, what is the nature of this attachment, your lordship? The nature of the attachment is not to cause my civil death. The nature of attachment is to safeguard so that I'm not utilizing those proceeds. And if your lordship just sees subpara 4, it is subsection 4 of section 5 at page 46, it's quoted, your lordship, of the judgment that it says that if you're in possession of a property, for example, if I'm in a house, it can be attached and I can continue to enjoy it till it is proved that this is a proceed of crime, and then only confiscation can happen. So what is the nature of attachment? Nature of attachment is also proportional. That you may have acquired this house. For example, I took that money from fake degree and I purchased my residential house. So you enjoy that house till it is established that there was a direct nexus of the flow of money into that house. So subsection 4 again puts that pressure. It again gives a sense of proportionality on basis of which section para 286, the Honorable Supreme Court says that there are sufficient safeguards. From the plain language of this provision, it is evident that
You are
several,
reading 286.
yes, sir. Para 286. What is that?
Yes.
From the plain language of this provision, it is evident that several inbuilt safeguards have been provided by the Parliament while enacting the 2000 Act. This provision has been amended by Act 2001 to strengthen the mechanism, keeping in mind the scheme of 2000 Act and the need to prevent and regulate activity of officers. As regards the amendment made to which the same are not matters in this and all that. Now, paragraph 6.4 on the next page, which is now where the application of Vijay Mohan Lal starts by the Gujarat High Court. Para 6.4, your lordship, is the opinion of the Gujarat High Court.
Therefore,
yes, sir. Therefore, what is clear is that it is only such property derived or obtained directly or indirectly as a result of an act can be regarded as. In the facts of the case, it is obviously apparent that it is only allegation, and the gist has been discussed is that the corporate debtor uses credit raised from the bank for purposes other than intended purpose to carry out the circular transactions with various companies and making overseas investments. There is no explanation as to how the property standing in the name of the corporate debtor and which form part of the assets sold to the petitioner are proceeds of crime, especially since these assets are neither overseas assets or that of the group company. Sine qua non, arrive at the determination that assets are proceeds of crime. The foremost requirement is that the author has to have reason to believe on the basis of material in his possession, which the authority has reason. Reason to believe cannot arise from mere suspicion, gossip, or rumor. Merely because the impugned order record alleged fraudulent transactions and diversion of funds, it cannot automatically lead to the conclusion that property acquired by petitioner.
Calcutta discount.
Yes, sir. So
We got Calcutta discount.
yes, your lordships, exactly. So, and I've given your lordships the list of those judgments earlier on, that note on judgments from Calcutta Gas Company. Onward. So this and your lordship will then see the end of this paragraph. In fact, these paragraphs are very important for us because they deal with reasons to believe.
Oh, they have discussed the decision also.
Yes, your lordship.
Calcutta discount is there. Yes, Calcutta discount is also there.
Yes, your lordship. And then your lordship's paragraph 8
Yes.
is with regard to alternative remedy. So here again, the Honorable High Court has held that when there is no nexus whatsoever, there is a jurisdictional fault. And there being a jurisdictional fault, alternative remedy, which is not efficacious, and it is Caesar over Caesar. Basically, it is the authority, superior authority, which is going to be deciding, is not an efficacious remedy. Therefore, the argument of alternative remedy in cases where action has been taken without any jurisdictional facts is amenable to judicial review, especially since judicial review is the basic feature of our constitution. And that cannot be taken away by any bar in statute. So, your lordships, this is this judgment, your lordship, which squarely fits my case, except the facts that this was, the allegation was that SBI said that you have diverted, and that diversion has gone into liquidation, and now that has been further diverted to Wells Fargo. So that chain, according to the High Court, is not established because the first step, which is identification, is not made, and second step, no reason to believe of that identification is given by the authority. The second aspect that I want to show to your lordships is that the law as it stands today and is being followed by all high courts is that PMLA proceedings, the seed of PMLA proceedings sprouts from the original predicate offense or the FI. So thus, if the predicate offence or FIR itself, as said in Vijay Mohanlal, is either quashed or a discharge is there, and now a new category has been added by the High Court, or if it is stayed, then PMLA proceedings cannot proceed. Because the offence of laundering, money laundering, is
Even if in a circumstance of stay.
yes, Your Lordship, I'll show that. Bangalore High Court, Karnataka High Court has just given that judgment, and all High Courts are now following this. In fact, Delhi High Court Justice Yashwant Verma in coal scam has in fact quashed PMLA proceeding because the identification aspect was not true.
But how do you balance the equities of both the parties?
Yes, Your Lordship. So equity.
Suppose the stay is tomorrow vacated
Yes, Your Lordship.
and the predicate offence is allowed to continue.
Yes, Your Lordship.
And it's a matter, different matter what happens in the trial.
I'll explain, Your Lordship. What happens is that
And in fact, even in the stage of trial, it is the realm of allegations only.
yes, Your Lordship.
Search is on the only basis of the investigation. It needs to be proved in the court of law.
Yes, Your Lordship.
Unless it's a proved offence, predicate,
Yes, Your Lordship.
then how do you, how will the PMLA?
The equities are balanced in this fashion, Your Lordship, that because it arises from the predicate offence, so the court has to decide. And
No,
this
what is the requirement? A mere allegation or substantiated allegation?
Your Lordship's a substantiated that.
That means making an FIR may not be the.
Thus, it's not sufficient for PMLA courts or for honorable high courts to not stay the.
But can they initiate or is there any bar in initiation? Suppose you are been alleged of an offence.
Yes.
And the procedure of which is they have reasons to believe that you are utilizing somewhere else.
Yes.
Is there any bar in initiating the proceeding of PMLA?
There is no bar of initiating. But what
Now, what we mean to say that is it necessary or sign up on that the offence, predicate offence has to be a substantiated offence, then only a PMLA will lie, or
No, Your Lordship, what I'm saying is different. What I'm saying is that the predicate offence allegations, for example, there is allegation of cheating.
correct?
Correct. So when that allegation of cheating is made, then we don't know whether that allegation is correct or incorrect or how probable it is. It's like the bail case.
Yes,
So
yes.
take a prima facie view.
It's a realm of speculation, allegations only.
Exactly. So on basis of that allegation, whatever follows, but what follows, Your Lordship, for PMLA is the identification that if these allegations are taken the way they are, then those allegations have given rise to some earnings, some proceeds. Only those proceeds.
That we have
Yes, Your
understood.
Lordship.
It should be confined to only those proceeds of those crimes.
Yes, Your Lordship.
If you are having some other source, those cannot be touched.
Those cannot.
be the subject matter of a PMLA.
Yes, Your Lordship.
It has a direct nexus with the proportionality of the amount involved in the predicate offence.
Very grateful. Your Lordship. That's one. And the second is that how the PMLA must proceed. So there are three stages. First is searches and seizures under Section 70. Second is preliminary confiscation attachment, provisional attachment under Section 5. And third is final confiscation order that is issued. So now courts, high courts particularly, are leaning towards the initiation being not quashed, but if the predicate offence trial itself is stayed, because there might be reasons that it's not prima facie made out, so the Honorable High Court or Divisional Court thinks that discharge should have been allowed, there can be various permutations. If the predicate trial itself is stayed, then PMLA proceeding should not proceed further, so that it results in a confiscation order much prior to me being held guilty of the crime, which is what Lordship recollects, and even Vijay Madanlal, the Constitution bench says that if it is acquitted, then the PMLA allegation falls with the predicate offence. So to ensure that because it is going to fall.
No, that is natural. If the basis is not there,
Yes, sir.
the structure has to fall.
Exactly. That is the point. So I'll just show to that respect, Your Lordships, a Karnataka High Court judgment, which has just come in December 22, and which is something now being followed, Your Lordships, by way of various orders, etc., in various high courts. And the very question which Lordships have posed to me is answered in it.
The Umar Reddy.
Yes, sir. Now here the allegations are about a similar amount, 40 crores. And this is the allegation at page 5 last time, is that the loan has been used for purposes other than those for which it was taken. And page 7, Your Lordship, see the last line of the first paragraph. Total value of 40 crores odd. The order of attachment so made by third respondent is what drives
Just a minute.
Sorry.
Which page?
page 7, just above paragraph 5.
Yes.
Lordship, the quantification is given of 40 crores, and the order of attachment so made by the third respondent is what drives the petitioner to the court in this subject. Then Your Lordships, I will skip the arguments, and if Your Lordships come to page 10.
Yes.
In the bold, Your Lordship,
Mhm.
the question that arises at page 1 is an ad hoc. Whether the enforcement directorate has the right to attach property of the petition. And number 2, whether the person under PMLA CIR number should be permitted to of the interim order of further granted the offense. So these are the questions which are spreading. And if the Lordship, page 24.
Page 24.
24.
Yes. Yes.
The questions are answered in this format. In clause of the aforesaid the effect code considers section. This is referring to Vijay Mohan Lal. In clause of the aforesaid conclusion, the effect code considers section of the act and later upholds section 5 of the act in terms of clause 6. Section 5 of the act is what is the attachment of the property. Clause 5B of paragraph 457 establishes the effect code holds that even the of PMLA or whose allegations are linked to a predicate offense, such as the predicate offense gets a in three circumstances: 1, by acquittal after a full blown trial; 2, on discharge by the competent court; and 3, on the proceedings being watched by the High Court in exercise of its jurisdiction under Section 4 of the Act. In these circumstances, the improved act under the provisions of PMLA cannot be permitted to be continued. Therefore, if the allegations of the predicate offense are considered pled, the offences under PMLA is the blood, what Your Lordships just observed. They are impregnable. Therefore, if the predicate offence are not permitted forward, the improved proceedings cannot. It would have been altogether different circumstances if the petitioners were all acquitted of the offence under the IPC or any other predicate offence under PMLA mistake. The situation in case at hand is not with regard to acquittal, but with stay of proceedings. Therefore, they are eclipsed and not extinguished. The apex court does not to the circumstance as to what should happen in a case where it is eclipsed. The apex court only dealt with the situation where there is an extinguishment of predicate offence. Therefore, it is necessary to consider the findings of the apex court as to whether attached orders should be permitted to confirm or otherwise. It cannot be disputed that at a later point of time, if the petitioners are acquitted, no proceedings under ECIR can continue. In that event, they are convicted. It is always open to the enforcement directorate pass an order of attachment or conviction as the case would be. If that be the right of enforcement directorate, since there is no determination in section number so and so, in the light of interim order granted by the court, so long as this interim order is in operation, the impugned proceedings in the considered view of this court cannot be publicly continued, failing which it would run completely counter to law as demonstrated by the effect. In somewhat similar circumstances, the division bench of the High Court of Madras in P. Shanako Monk's case considers this very point as to whether what is the effect of the state order and has held as follows. So therefore, in Madras High Court also, same principle is being followed, your lordships. And if your lordships will kindly now come to page 33, 34, on basis of Vijay Madan Lal Chaudhary, J. Shekhar, which is the judgment of the Delhi High Court, Madras High Court judgment, the Honorable Karnataka High Court stays the provisional attachment till the disposal of the writ petition and the criminal petition. And the provisional attachment order is kept in abeyance. Now, applying this to our case, your
This is in paragraph 18 over.
lordships accepting and yes,
And-
paragraph 20 to
18, I think.
20 subclause 2 and subclause 3. So the deed was granted in subpara 22 and 23.
How do you protect the interest of the department?
Lordships, we had previously suggested also, and we had previously suggested that if the lordships recollect Justice Rishikesh Roy's order, where we have also
Original documents.
we have deposited those original documents, your lordships. Those original documents have been verified. The land is worth 40 crores. Given the not even the circle rate, below the circle rate, it is minimum 40 crores. Now the allegation, their provisional attachment was 25 crores. Even if we take that there was 15 crores taken out, 43 crores, 83 crores, 83 crores admittedly is the amount of money which was lying in the foundations and the director's accounts. So that is not even their case that proceeds of crime are 80. At best, their provisional order was the extent of 27. Today, I am saying take this security because it is my university land. It is verified land. I would not have building the university on it until and unless the land was in mine. Properly verified, documents are before your lordship, original documents. And today, as a university, your lordships, I have to pay salary. I have to replenish my endowment account. I have to pay renewal fees. I am running at least 30 courses in different streams, including a law college and engineering courses, technical courses. The state of Assam refers their students to our university, granting them scholarships that you go and study in this university. And I will show from their affidavit itself that each of their allegations against me, which they have thrown up in several by several degrees, are incorrect by their own affidavit, your lordship. So what I am submitting before your lordships is that in the present case, the correct course to follow, because for me, washing is what I would plead to your lordships. But as an officer of the court, your lordships, what I would submit is that the correct course to follow is what the Karnataka High Court has followed. That the provisional attachment order be kept in abeyance. The stay to continue, and in view of the fact that the proceeds as alleged by them are adequately satisfied by the value of the land, which I am putting at their disposal at this point of time. And I'm also willing to take an undertaking. I've already given an undertaking, I've instructed your lordship. I have already given an undertaking.
What is the scale of the predicate offense in your case?
Your lordships, now that has been stayed on various grounds. First, what they do, your lordships, is that they do not follow the procedure under section 17. They come and raid my.
No, no, no.
I'm
What-
just-
On
I'm
the
just-
predicate offense, the
Yes, I'm
separate
just
case.
telling you about that. They come and raid all my premises, including personal premises, my grandchildren, this, that, and everything. And they seize everything without following procedure. There are at least 3 rooms full of documents which they seize, which include degrees, mark sheets, attendance registers, all the records of the university. So they were not providing those documents. So I asked them for documents. So in this manner, your lordships, today the Honorable High Court has stayed the predicate offense. And on basis of this order, your lordships, the trial court has now adjourned the matter because the Honorable High Court has said that the proceedings in the High Court can be decided. We cannot put the cart before the. So your lordships here.
Just a minute.
Paragraph.
Yes, yes, yes.
Yes. Therefore, they were not giving us the documents. They are voluminous documents. The direction is in the meantime, until the said process is completed, proceedings before trial court may be kept in abeyance as was done so by the interim order of this. And then your lordship, on basis of this, the trial court by its order dated 6/22 has instructed the IO to carry forward the process and has kept the trial in abeyance until the process is complete. Now, your lordship, regarding their arguments of prejudice, because this entire, and the court has also stated about it. Your lordship, my third friend is very keen for your lordship to know their conduct, because they have cross appeals before the Supreme Court, and they have not, in their affidavit, revealed that they have also appealed against the High Court order in the Supreme Court. So the adjudication, whether there was any violation or there were issuance of any fake degrees itself is now stayed by the Supreme Court, Your Lordships. The revocation of my university status on basis of these allegations today stands stayed by the Supreme Court. I will make a final bit.
Yes.
Now, Your Lordship, I think
Now, in the Supreme Court proceedings, this one, which is the effective order?
effective order, Your Lordship, the first order. Is the last day. Date once, the revised status quo as the effective state affected by part.
Yes.
This was with regard to the inquiry under section 48 of the University Act. And now the state says it is not connected to this.
Where do you get the date? So, one,
Your Lordship,
1620,
after- Yes, Your Lordship, just about the date of the order.
is it 162021?
Yes, sir.
Yes.
Your Lordship, now Your Lordship will quickly just take this and I will show how false their allegations are as per their own documents. And I'm showing that only, Your Lordships, because various arguments of prejudice have been raised against you. And Your Lordship's internal page, at page 6, the paragraph 62. What page is that?
Of course, 62, 1046.
Your Lordship's the pagination has
Doesn't matter.
05.
We got 162 paragraph.
62
We
paragraph.
we have 62 paragraph.
Yes, Your Lordship. What they say. Deponent also begs to state that petitioners have completely blemished the history of providing assurances in the form of ZIMA and fixed deposits in front of multiple courts and getting favorable orders by way of misrepresentation and deceit. While so-and-so in court of chief judicial magistrate, the petitioner against ZIMA got an order dated allowing them to withdraw their funds while not letting the court know that the enforcement directorate had already attached the frozen accounts by the petitioner attachment date. Later, they tried to fool the Honorable Supreme Court by showing deposit slips of this much during the hearing in 2019, when fixed deposits of 15.10 crores were already encashed out of after securing evidences of deposits. Lordships, this is, I have objection not only to the content but to the language. How can anyone fool the Honorable Supreme Court? And Lordships, I have just shown the trial court order verifying this 15.10 crores.
What about this attachment, provisional attachment order by the ED? Is it a correct statement of fact?
Yes, Your Lordship, the provisional, in fact, we've been going to the Supreme Court advising on the basis of this, Your Lordship. Because as I, in the beginning, Your Lordship, I've given that list of dates. First, there is seizure by CID. The same proceeding, the same assets are seized by enforcement directorate. They are not different. The ECIR attachment, your lordship, is of the same assets as the CID in the predicate offence that's attached. Now, your lordships, they have put before your lordships 161 statements and a report by UGC. Now, the report by UGC, your lordships will find at page 1060. It's annexure 4. I'm sorry, your lordship, this is not a report, this is the notification establishing by university. So they have put this to show that no off-campus sites can be established. Which I say, yes, they should not be established as per UGC rules. Now on the next page, your lordships, there is a UGC report on basis of complaints. And whose complaint is that? The visitor's complaint, not a single student has complained, not any third party has complained. Only one complaint, that of the visitor. Of course, that is a very weighty complaint. So, your lordships, on 1st of August 2013,
Referring to which page?
annexure 5, your lordships,
1061.
status of CMT University. Your lordship sees the second last paragraph. UGC committee visited CMT University on 1/8/2013 with nominees of AICTE and NCT.
Yes.
Now, again, your lordships, on 1st of August 2013, my premises were sealed by me. As per UGC norms, and your lordships is aware, the management also has to be given notice of any inspection. No notice given to me. This is a unilateral interim report on which they are harping again and again. Now, this is a report which is submitted unilaterally at a point of time when the university is sealed. And your lordships, they make certain observations. And in fact, if your lordships turns the page over and the third paragraph, in their FIR, they say there are thousands, 20,000 students, 27,000. What is the number that they are giving here in the UGC report? 1,640.
Which paragraph?
Your lordships will see the third paragraph, the Principal Secretary, Government of Meghalaya.
Yes.
Lordship will see the last, I'll read this paragraph. The Principal Secretary, by letter dated 2014, informed CMT University has been dissolved by Government of Meghalaya under Section 48 regarding validity of degrees. It was informed that hearing or representation by students have been completed to various parameters. A total of 1643 students attended the hearing and 48 were absent. A total of 1,479 cases, the degrees were found to be invalid and they are being intimidated separately. List of valid may be available with the state government. So as per the UGC report, I don't have 27,000 invalid degrees. I have only 1,479 invalid degrees, which also I'm questioning. But prima facie allegation taken at whatever it is only 1470. And everything else is subject to the outcome of the Section 48. So this is the sum total of this UGC report, which has been cited as the report which blemishes the committee. Then your lordships will come to 160. We've also challenged this report. Now your lordships will come to the 161 statements which have been put by them. Annexure 11. 1071. Page 107. Also notice one thing.
1071, Annexure
Yes.
11.
Yes. Fortunately or unfortunately, I do a lot of criminal work. There are some things which have popped out in these 161 statements. Your lordships will see 1071 and 1072 are statement of the same lady, Srimati Asifa Nongram. And if your lordship sees the date in this is 20th of May 2014. The first statement is recorded on page 1071 on 20th of May.
Second is 21st of May.
Next day, your lordship will see the change in the statement. On the first day, what she says is that mark sheets used to come, mark sheets used to be printed, they used to be filled, and they used to be given. Now, mark sheets, your lordships are not given. And lordships are where mark sheets are given mid-semester, end of semester, duplicate mark sheets are given, corrected mark sheets are given. So mark sheets are not awardable. So this material, evidence, is not anywhere close to the evidence which is required to be. And not a single degree is seized from my premises. What is seized is a provisional certificate, which I will just show your lordships. At page 2088, texture 30. Yes, sir. The texture 30.
Page
Page my lord 1077.
10.
1077. Record 12 or 13. 13 is my lord 1079.
There is a confession statement by Asif.
Yes, confession statement is 13 is the document of documentation.
Yes, your lordship. This
That is annexure 13 my lord 1079.
lordship, this is
07.
one of the witnesses. And texture 30.
Confession before whom?
Confessional statement of active
Before
judicial
ED, your
minister.
lordships.
No, judicial minister.
No, judicial magistrate.
CID.
No, judicial magistrate.
Yes.
GMFC.
Now this confessional statement also your lordship will see. All that they say is that we are not aware that this university is dealing with fake certificates. We were told that this is a private university, so it usually happens like this, as the students cannot collect the certificates every now and then, so they collect it in one. So even this confessional statement, your lordship, I don't see what confession has been given in that. If your lordship turns to the next document,
No, but who is he an accused or what?
no, your lordship, these are all employees from which they have forced these statements. In any case, at best, they show that there are mark sheets, these statements. They nowhere show that degree has been granted. And I'll show that your lordship by the next document,
That means this is the 164 state.
161 and then
No, no,
164.
this is
Yes,
164.
confessional is 164.
But why has it been termed as confessional statement? It's an accused. At best, it can be termed as 164 statement.
Employee of the court.
Co-accused.
Yes. Then your lordship sees an extra search, which is information which is given by one of the students to the enforcement directorate. The lordships that he took admission in 2011 and he has enclosed the documentation. Now, if your lordships turns to the next page, This is intimation of the university that you start preparing your thesis in 2011. They are saying that these persons never conducted these courses in the university. Now on 6/7/2011, your lordships, he is directed by the registrar in the last paragraph.
Page,
Page, your lordships. It's dated 6/7/2011.
1079, my lord.
1079.
127 selected 13.
Yes, that is the by one student.
Yes. And next page is dated 7/2011. Next,
Yes, your
next to
lordships,
1070.
1080.
108.
This is by the university to the student.
Yes, your lordship. Now your lordship sees the last paragraph. It says start research work and prepare thesis under supervision of our authorized guide, Dr. Vikas Chandra Agarwal, as per the address mentioned in your synopsis. Then your lordships is the next page. This is coursework of the completion mark sheet. Now, this is the courses which he was attending prior to starting his thesis.
Yes.
And then your lordship turns to page 1082. And this is in December 2012. So after 1 year, your lordships, of thesis submission. So this is the second year of the student. They give a certificate that he has submitted his thesis in the university. This is again not the degree. And then your lordships at page 1083. This is an intimation to him that your viva voce examination will be conducted on 18/2013. Two months down the line, he's told your viva voce exam will take place. And then your lordships will turn to the next page. This is on 28th of February. 18th of February is his viva voce exam. On 28th of February is a report of viva voce that you have qualified, and we will be giving you a provisional certificate. Next page, page 1085. Now, your lordships will kindly see. This is what they are saying is a degree, but your lordships will kindly see this certification. It says provisional certificate. And I will read the certificate so that there is no confusion whatsoever. It says this is to certify that the proposal for the award of PhD degree in the subject of so-and-so under the faculty of so-and-so to so-and-so registration number so-and-so has been awarded by the university as per UGC Gazette. So this is a proposal for award of PhD degree. Because after this starts the external examination. Because this will go to UGC. UGC peer group will review the thesis, quality of thesis, then it will come back. Possibly this person might have to improve his thesis or write more or repeat the entire process.
But is there a this, scope of issuing a provisional certificate
Yes, Your
for
Lordship.
PhD,
That is the procedure that
even for PhD?
yes, Your Lordship. That internally to first finish the thesis, it is internally reviewed. Then 10 copies are sent to the UGC. And that's why they have found multiple copies, Your Lordships. So 10 copies of the same thesis is sent to the UGC. UGC sends it to its panel of peer reviewers. Those peer reviewers make their comments on it, send it back, it comes back to us, after which some process takes place, and only when he qualifies is he granted the degree. So, as far as this process is concerned, we have not granted a single PhD degree. All that has been granted is this provisional certificate. And this is their document, it is not my document. This is the document which they have put before Your Lordships as seizures made by them.
And it is the contest again, this is certified that
This is to certify that the proposal for the award of PhD degree in the subject of management under the Faculty of Commerce and Management to so and so, it's the name. Kumari so and so, Mr. Srimati Kumari, Srimati Kumari. Registration number year so and so on the topic so and so has been awarded by the university as per UGC Gazette notification. So this is only the proposal.
the proposal, why is it a form of a certificate? And
Because this then goes.
and use of the expression awarded. You do not award a proposal.
For the award.
No. The expression is not awarded. The expression is awarded, has been awarded.
Yes.
And this looks like, no doubt it's got it contains the expression provisional, but it's a certificate.
Yes. So the certificate cannot by us and sent to UGC. And the PhD, this is well known that the very fact that you completed the thesis successfully is itself an academic success.
But the degree of this PhD is given by the university, not by the UGC.
The lots of people can after the UGC approval. The lots of there are regulations on PhD degrees. So as per that regulation, we give them the leader, we give them the supervisor, and then the supervisor supervises the PhD work, but it has to be reviewed. And on basis of that, the PhD is done. UGC, you're not correct, there's only one objection, that only if you have not been at the center, if you were at an off center, they were saying that the degree was not valid. But if you have attended the course in the university, and UGC had no issues, and till date it continues to recognize us, the website shows. one more point I want to cover. They say that there are two Allahabad High Court judgments that these are pending. However, if your lordship still sees, the ratio of those judgments are that we do not know as of now. Section 48 proceedings are still pending, but till they are decided, if your lordship just turns to the first judgment, which your lordship will see at page Allahabad High Court. Sorry, your lordship. Your lordship 1092.
Yes. Next question, we're going to look at that.
Yes. Now your lordship will come to the end of this judgment, the last paragraph. Justice Vikram Nath's judgment, as he was in Allahabad High Court. There is no determination so far. The last paragraph your lordship will see, if ultimately UGC declares that degrees granted by the university to be valid, petitioners will be at liberty to approach this court, and even then they will have to satisfy the court about observations according to the preceding paragraph so as to derive equitable relief. So this issue is still at large. Similarly, the second judgment of Honorable now Chief Justice Justice Chandrachud, the last part of the judgment, para 15, the next judgment. It starts from 1106, and I'm inviting your lordship's attention to para 15. Again, your lordships, there's no finding that the degrees valid or invalid, and liberty.
Why were this question
Your lordship, this was with regard to some employments where they questioned the degrees because
no,
of,
why in the Allahabad High Court CGM University?
your lordship, because our graduates had applied for jobs there. So a question was raised because based on paper reports, your lordship. So this liberty was given that if they are proved to be valid, then you can approach the court again. And Honorable Supreme Court has already stated that proceeding, so this is still a question which is open.
The second judgment is dated
29/1/2014.
14. It's a division bench.
Yes, sir. Next 25. Right, your lordship's attention to the last two documents. The texture 25 and page 1201. These are their images, your lordship, of my university, which your lordships can see is this entire pillar. It's 50 acres land in our name and possession. We have built the university on 30 acres. And this is the same land of security which we have furnished to this quarter. And this is a 2011 satellite imaging, which your lordship will see there are rooftops of 3 buildings towards the left circle. So my university, this is a satellite image, your lordship. So lordship can see buildings and 2013 save, 16 save. Your lordships can see the development in 2016 image. 22 further development. So their allegation that we were running out of a tin shed is absolutely incorrect and malafide. And all these buildings are 5 floors each. And your lordship, we had a city lease with regard to a premises in the city. When we had initially started, we put those lease deeds also on record. So to say that we don't have any infrastructure, UGC has not de-recognized me till date. On what basis is this allegation made is the question before your lord. So in sum total, your lordships, what I want to submit your lordships is that as far as the predicate of itself is concerned, there is a very slim chance of them being able to prosecute me and get a conviction. Number one. Number two, your lordships, on jurisdictional issue, there is no reason to believe that the amounts seized and attached by them are relatable to any proceeds of crime. There is no identification of the proceeds of crime with the allegations of the crime. Thirdly, there is no reason to believe that I shall be concealing or misutilizing these resources or assets. Next, your lordship, that on strict interpretation of criminal law, no steps could have been taken by the authority for provisional attachment. Specifically with regard to allegations going beyond the criminal aspects. So therefore, the rest of the fees which was generated or the interest generated from my other legal means could not have been attached. Next, your lordship, on application of Vijay Manmohan Lal. The action has to be very specific, very contained, and in strict accordance with the provision of the law. And thus, any attachment beyond the jurisdiction as granted under the statute is liable to be struck down by your lordships. The first OCs issued by them to us, your lordships, there are 2 OCs issued. The first OC, your lordships, in paragraph 25, has no reason to believe. There is no explanation in writing that I have reason to believe that this was generated from so-and-so, and therefore there is this nexus of connection. On basis of that, your lordships, it sees the first OCs, it is liable to be quashed at the very first inception. In view to make good that deficiency, they issue now in 2022 fresh OCs to me, under which they go and attach fresh properties of mine, fresh assets. which I've challenged in the second writ petition. Now, going by the Gill, Mohinder Singh Gill principle, etc., they cannot furnish reasons subsequently by a fresh action. There has to be something new which comes to light on basis of which a fresh action can be initiated. A new OC on the same grounds cannot be sustained by just adding a few paragraphs to that OC, saying that this FD was converted into a new FD number. Therefore, we see that there is cycle. As explained to your lordships, the FD numbers will change. So even the second FD, OC is without any jurisdiction, and the reasons to believe are a complete sham. And in an effort to cover for the lacuna that existed in the first OC.
Can we have a look at the two documents?
Yes, your lordship. Your lordship is the first OC. Your lordship, fine. And page 8 of the Your lordship is just page 658 of the second writ petition. 262.
That's the IA.
So, your lordship, the second writ petition has both the OCs.
2723, not 226.
This will be part 4 of that writ petition.
Page
658. This is the document dated 25/2007. Probably part 4.
Yes.
Your lordship will see it's a repetition of the charge sheet and various things. The lordship will come to page 675. Paragraph 9.
Six fifty.
675.
Yes.
Lordship, paragraph 9. They say that the above mentioned properties are likely to be withdrawn, transferred, or dealt with in such a manner that I have reason to believe that if no provisional attachment order is passed in this case at this stage, it may result in frustrating the chapter 3 of the PMLA Act. Now, your lordship, what is the reason of the suspension? What has given this reason to believe? There is not a whisper of that. It is the mandate of the law in writing their petition. Now, your lordship, to cover up for this lacuna, and the first order of stay by this honorable court was given on this basis only, that the mandate of the law has not been followed. Now, the second OC, your lordship will find at page 859. Lordship has page 859.
Yes.
Now, your lordship will see that this is page 860. Now they add to the reasons in 2022. And it is again relation of all the legal proceedings which have taken place.
So we have to continue tomorrow.
Very well. But it will fix up time.
Yeah.
Let's complete our agreement tomorrow. If it required, have it tomorrow. Positive time. Not allowed. Complete. This again. Tomorrow there will be motion immediately after the motion.
I'm
Around
sorry.
11.
Cannot say the time. Depends how many motions we have.
I'm sorry to trouble your lordship. In respect of item number 21, there is an interim order till it that may be kindly accepted.
21.
21.
Any matter where interim order is there,
I'm deeply obliged, my lord.
Item number 20, we have some artistic matter related to family matter. A date may kindly
date he'll give. Any matter where interim order is to be extended. 32. Interim order is there. 20. There was a bail matter. About to interim. Interim order to continue till the next order. There was a bail matter. Some bail could liquid. It appears that the scanned copies of the court record have not been received. Registry is there. Issue reminder for immediate transmission of the scanned copy of the case record. List of the three. Photos item.
lordship, item number 36, Friday, some artistic there. But
Friday not possible. Next week. Give a date. Friday we've got many matters.
Monday,
He'll give the date. Take it over you.